Agwashi, Aroyat colleagues of the 25th Resources Development Committee members. I'd like to greet my legislative services staff. Good morning. And also to our partners here with Navajo Nation. I just want to greet you all. Good morning, our Navajo Nation employees. We do have some land board representatives here, and then also some private partners that Navajo Nation partners up with. So again, this is day 2 of the work session that we had allowed to listen to the right-of-way streamlining process, where there's a lot of other components that actually were brought up yesterday in regards to home site lease, how that impacts right-of-way. We've got the 750 buffer that also impacts the right-of-way right off of a major highway corridor. We've got the grazing permits, the permit holders out there, whether they're actually valid grazing permit holders or not. We noticed that they were also part of the variable that has complex this whole system of getting right-of-way approved and out the door a lot faster. So I just want to welcome everyone here again to the Division of Dene Education Auditorium. And again, this is a Resources Development Committee work session with Division of Natural Resources, Division of Economic Development, Navajo Department of Justice, Office of the Controller, Navajo Nation Fiscal Recovery Fund, Office in the U.S. Department of Interior, Bureau of Indian Affairs. Although we've got some of the enterprises that the Navajo Nation works with. So at this time, I'd like to go ahead and request to get a roll call. Rodney?
Madam Chair, members of RDC, this is roll call for Resource and Development Committee's work session with the Division of Natural Resources, Division of Economic Development, Navajo Nation Department of Justice, Office of the Controller, Navajo Nation Fiscal Recovery Fund Office, and the U.S. Department of the Interior, Bureau of Indian Affairs for Tuesday, August 29th, 2023 at 10 a.m. Roll call. Honorable Brenda Jesus. Honorable Brenda Jesus is present. Honorable Casey Allen Johnson.
Vice Chair Casey Johnson is present.
Honorable Casey Allen Johnson is present. Honorable Shauna Ann Claw. Honorable Ricky Nez. Honorable Rick Nez is present. Honorable Danny Simpson. Honorable Danny Simpson is present. Honorable Otto So. Madam Chair, you have 4 members available, but you don't need a quorum for this work session. Back to you, Madam Chair.
Mr. Tahi, and going on to the next item, I'd like to go ahead and request Vice Chair Honorable Johnson, if he would open up our session here today with a prayer. Vice Chair.
Yeah, Madam Chair, thank you for that. It's an honor. Okay, we'll just go ahead and remove our hats and bow our heads in prayer. Dear Heavenly Father, come to you this morning to thank you for all the beautiful blessings you bestowed on each and every one of us. Thank you for all the moisture, and thank you for all the the rain that we have received. Very thankful and very grateful, and that we all are blessed. And I ask that you continue to watch over each and one of us, travels, coming here today, and as we return home to our families, that we have a safe trip. I ask that we continue to serve in the best interests of our Dene people, and really work together here today to come to a solution, and fix these issues that are in the way of progress, and in the way of a lot of these projects that the people need. So just ask that you continue to guide us and direct us, and continue to keep us healthy and strong, and let's have a very productive meeting today. Yeah. Say all these things in the name of Jesus Christ, amen.
Vice Chair Johnson for that beautiful prayer here this morning. Next, I'd like to go ahead and open up for introductions to the Resources Development Committee members. Again, Vice Chair, I yield the floor over to you for introduction.
Thank you, Madam Chair. Good morning, everybody. I'm the RDC Vice Chair, Casey Allen Johnson of the 25th Navajo Nation Council. Shay my days Kishni National, Ashkan Hazobashi, Anani Deshiche, Senator National, Ego to National, Tilabeda Nasha. I represent Cameron, Coal Mines, Lonnie Lake, Bird Springs, and Loop chapters, District 3 and 5 on the Western Agency. So those are the communities I'll be representing. Thank you for being here.
Vice Chair Johnson, Honorable Rick Ness.
Goshila Shanand Arno Senegi Resource and Development Committee, staff Karnas Wador and Kissendas Nishiki, Doanotsko Corona Harchin and Senator Shikeros and Rickness in Shihawasan and or Zayt Hachin, Bushes Chains and Habitin the Shichedo, Kia Ani A, Hadashanala Hotide, and then Schlido Nave, Tohn San Juan River, Bigato, San Juan Chapter East, Arohastrago chapters, Banashin Shigate, Sada Khan, Sasat Nanik, and Nena Nazar, Do Kate, East Tosacado, East Dash, Yat Epena.
Honorable Naz, Honorable Danny Simpson.
Yate, then she gave Shintani, Shay, then Simpson, Lay, Hanatri, Nashka, out of the name Shini, 20 inch, Simple Chen, Nasas, Nala, but his chief. The 8 chapters were Nashka, Personal, Naeasy, Lake Valley, White Rock, Sente, Crown Point, Manjiskis, and Stand Rock. Yate Nike Bishi. Thank you, Madam Chair.
Honorable Simpson, Ado Inda Kuna Dahab Sing Brenda, Jesus Dashanido, Setna Jinin Slot, what it eat, Bushes Chin, Honarahi Dashachate, Bohana Dashanal Akota Son and Nishle, Ado Nature Hot Soto, H in Tado, Easy Ajen Linigi. And Banat Anin Shlom Banasha Ado. Had Sedan Trago Kwagin Hano for people that are present here in person and also to listeners on the call. Thank you for being here with us. Again, a day 2 work session in regards to how do we streamline the right-of-way process through regular amendments through Title 16, and then also even setting up a temporary language provision to get the projects under ARPA at least built out, and that is one of our main priorities as we are pressed for deadline. At this time, I'd like to go ahead and yield the floor over to our legislative services staff for introduction.
Good morning, Madam Chair, members of RDC, those present, those online. My name is Rodney Tahi. I'm the legislative advisor for Resource and Development Committee. I'm Kiani and Senjikina. I'm originally from Arizona.
Yat Ebene, Leslie Sosianishna, Chihi Nishna, Tohaglini, Dashachin, Sena Bithy, Dashache, Vana Jashanale, at Setia Nasha, and I work with legislative branches. Thank you.
Morning, everyone. Shay Leonard Moses, Shay Twilson, Asha, Shishno, Hanagani, Pashin, Ashi, Dashachate, Mansanole. Welcome, everyone.
Good morning, Yat Ed Hanelso. She Mariana Khan, the Shajina, Donna Enish, Haligi 8 Port here, Dreaming Mission. Ahi Bashes Chin, last year, Dashachin, Senator Kena A. Dashanala. I work with the Resources and Development Committee and all of the Navajo Nation Council and work with the Office of Legislative Counsel. Thank you.
Good morning. My name is April Quinn, and I'm also an attorney with the Office of Legislative Counsel.
Thank you, legislative services staff under the legislative branch. So right now, I'd like to go ahead and just announce that this is a public session here. So we do have refreshments. I believe we do have the ladies and the men's restroom codes here on this board here. So again, thank you. And I just want to give a little recap from yesterday's meeting. So Rodney, if you can bring up the document so that I have the attendees review this document. So yesterday, are you all able to see this? Yikes. 0. Rodney, is there any way we can increase the font or Gotcha. Okay, so yesterday, just listening to the dialogue of the important stakeholders, and of course, everyone that was here yesterday are stakeholders to this discussion. Now, this work session was scheduled to really understand where are some of the barriers to getting ARPA projects completed, and not just that, but going forward, any other projects that Navajo Nation will be submitting grants and hopefully getting funding to do these infrastructure built out. So one of the main areas that came up was the home site lease requirement. Now, a land department and DNR will have a revised requirement for disturbed land, because right now, a lot of our constituents have been living within a 1 acre land for X amount of years, but they still do not have a home site lease. And one of the requirements I know through NTUA is that you need to have a home site lease to get water, wastewater, electric, or telecommunications. So Mr. Halona did mention yesterday that they're actually packaging a language provision that will just address the temporary ARPA project. So legislation requests should be ready by the 23rd of September for ARPA projects. So again, this is what we're going to be awaiting for. So hopefully by the 23rd, we get a package from DNR, Navajo Nation Land Department, so the RDC can drop a legislation. The second part is the ARPA projects that are for home renovation and improvement. It was told to us yesterday that this does not require a home site lease, because again, we know that a lot of our constituents have been living there for X amount of years. So this is an area that I was hoping that Mr. Halona would be here this morning, or either Mr. Harlan Charlie to really address the next steps. So one of the tasks that we're looking at here is, do we need a letter to clarify item number 2 and 3? The third one is the water wastewater project extending beyond the 1 acre land. So later, when a home site lease is given the legal description, the coordinates, the lat and the longitudes. So oftentimes what happens is within that 1 acre, it's still not a reasonable size land to have the leach field. You got the septic tank, then you've got the leach field that often goes outside the home site lease. But apparently Navajo Nation EPA wants NTUA to stay within the 4 coordinates of the home site lease. So this poses, a impact to having our constituents get water and wastewater on their land. So this is an area that we also need clarification. So do we just need a letter from DNR to say that we just write a letter to all the important stakeholders within the Navajo Nation executive branch that you really don't need this? Or how do we exercise the option of going beyond the 4 coordinates of a home site lease? So that's still yet to remain known and get more clarification. So that's the area on home site lease to address the temporary ARPA projects. Auto Inda, we went into item number 2 is the policy amendment and changes. So again, yesterday, Title 16, the Navajo Nation Code, you've got subsection 1401, 1402, and 1403 that was often addressed, which definitely needs addition and deletion of language provision. So the concern is to maximize the true compensation to a grazing permit holder. And when a permittee has no livestock per sheep units and the range unit acreage information poses an uncertainty of what should be done. And again, this was a question or a comment that was brought up by legal counsel yesterday, Mr. Irvin Chi with DOJ, saying, how do we determine the reasonable amount of compensation if a person is just holding a grazing permit and yet they have no actual physical livestock or even a physical tally count tied to that permit? So with that, that would require RDC and stakeholders to continue discussion on items 1 to 6, because we're talking some in-depth legislation amendments. And then going to item number 2 is one of the areas that was mentioned by Mr. Halona is digitize the permit holders throughout the Navajo Nation. with range unit township information to make research accessible. So what's going to happen is, and this would have to be in collaboration with BIA, because right now what is mentioned is we've got grazing permit holders out there. So oftentimes Navajo Nation Land Department still has to go back to BIA and ask for the information, you know, in terms of where are these permittees actually located, so that Land Department knows which permit holder to go to get consents from. So that's another area that remains to be discussed, and how we're going to address this going forward. Otto, the third item is the grazing official need to educate their constituents regarding the new process of half-mile radius. And this is per the 2016 home site leasing regulation amendments. And then the true permittee with active physical tally count of the last 2 years. So again, this was mentioned yesterday by Mr. Halona. When there is a project proposed, they, per the 2016 home site leasing regulations, they only go within a half a mile of where the proposed location of the project is going to be. So if there's no permit holders within a half a mile radius, they proceed with the project, and on their compliance form, they just put no permit holder or whatever. And then not only that, but what they consider a actual grazing permit holder is that they actually verified the last 2 years of physical tally count. So oftentimes you've got permit holders that are further out that probably aren't really valid grazing permit holders because they never had their physical tally within the last 2 years. They're considered invalid grazing permit holders. And this was a concern. How are the grazing official, land board, and the farm board conveying this accurate information back to our grazing permit holders, you know, out on the Nebekea? So that is also an area that needs to be addressed. And this would have to be through Department of Agriculture. Otto, fourth item is regulations of the 750 corridor that was made a law in the 1950s through a Navajo Nation Council resolution. And corridor for all infrastructure line off the highway right of way of an additional 100 feet need a process of who and how to use the land. So again, this is another area that was posed yesterday. The 750 corridor actually is per the legislation by council back in the 1950, I believe it was 1957, that this resolution is only for economic development. But yesterday, the recommendation again from DNR Division Director, Mr. Halona, is why can't we do an additional 100 feet to have all infrastructures? Like we're talking fiber optic, we're talking electrical, water. So again, that would have to be a further in-depth dialogue going forward. I mean, we can't address this all in a 2-day session, because again, we always have to have legal counsel. And again, as stakeholders, we've got NTUA, we've got other departments under Division of Natural Resources that have to be at the table to really share their expertise on what would be more quantifiable going forward. And then number 5, Fish and Wildlife request to redo GPS coordinates on already approved home site leases. Need clarification on this request. So this was another area that was brought up by, I believe, NTUA yesterday, where Fish and Wildlife is, or actually the grazing official from Bastla, where Fish and Wildlife is telling an already approved home site lease, and yet they want the individuals to update their GPS coordinates if there's already a home site lease. So why this is being requested by Fish and Wildlife, again, that's something that we need to get verification on. And the biggest one that was mentioned to us by legal counsel yesterday, Mr. Irvin Chi, was probate. There is no way around a probate. I mean, a family has to go through it, and how do we streamline the probate process? Is there alternatives? So again, since this is in the 25 CFR along with the Navajo Nation Title 16 code, then this is something that needs to be in-depth research again, in hopes that we can make some amendments to Title 16. So those are the areas that still needs further dialogue with RDC and the important stakeholders of these 5 items that were in the column 2. Now, item 3 is eminent domain and compensation. This is 16 Navajo Nation Code, section 1401, 1402, 1403. Now, this here was, I think some people got clarity yesterday, and there were still some information that remains to be, I guess, clarified. Number 1, a grazing permit holder does not have the permission to say yes or no to a project development. It's what we learned yesterday. Now, where this is written, we need to know that as leadership and as everyone else that are dealing with projects. And then the second part is a grazing permit holder can be compensated for economic damage. Of course, that's in the Title Code 16 under section 1402. Then the fair market analyses for right-of-way conducted with compiling of rates from other tribes, BIA and BLM. The Navajo Nation has been charging an average rate of low and high amounts, need clarification. So yesterday we had Minerals Department Director, Ms. Cheremiah, share this information with us. Now, I understand that we're right in the medium or the average range when it comes to charging for compensation in case there's a development going. But one of the areas that I noted where it says need clarification is, and I think a lot of us, you know, walking away yesterday still wanted to know, what is the process? What's process A when a determination is being made on compensation? So that's what I have in this next column. Need more clarification on process to determine compensation so that we all collectively understand and have the same level of understanding of what is the due process or the steps to determine compensation. So that's probably something that we would need to get more clarification on, whether if it's today or going further, scheduling on minerals and DNR on our next RDC agenda. But we would like to see if we can get a PowerPoint presentation on that. Then item 4 is the General Land Development Department. Don't use eminent domain, but assist in finalizing the client's requests. So Minerals Department is responsible for determining the fair market value of the compensation to a permittee. And then that also, we need clarification. So if General Land Development Department saying that, okay, we don't exercise or don't have the language of eminent domain within our department, but a lot of it is referred back to minerals, and we just need that clarification. And that's just where I don't know if a workflow diagram would be more suitable just to illustrate or demonstrate who is really responsible for what. And then that will go back into the title code amendments that we would need going forward. And then item 5 is what is the process of compensation? And that's where I request share the stats from A to Z. So again, if it's not going to be this work session, maybe this is another item agenda for RDC to go with going forward. So again, this is basically a synopsis of yesterday's dialogue, and I'm really glad that we had this discussion. So again, we're going to be adding to this if there's additional information or additional topics that we need to add and tasks that we would need to add to. So this would really keep RDC and the stakeholders at the same level of where we need to be. So I just wanted to share that with everyone here today and also to the listeners on the call. And I don't know, I'm not going to ask for any questions right now, but I just wanted to share this as we had our legal counsel review this document before we were able to share it with you. So this is from yesterday's discussion, my colleagues, and also to the stakeholders that are present here this morning. So again, we are more than, I don't know, Ms. Khan, are we able to share information by email to the stakeholders of Navajo Nation this, or is it okay? What we just shared up here?
Madam Chair, what you have up there are just essentially notes on what was brought up at yesterday's session, and I don't see any problem with sharing those keynotes that you put together. And thank you for sharing your notes with us.
Yeah, and again, it would be great. So just keep everyone at the same level and what the expectation is going forward. So if you had provided your email address, we definitely will email it out to everyone here at the end of today's session. So at this time, I'd like to go ahead just real quickly before we go to the next item on the agenda. So if you look at the item on the presentation items, I believe we will be going into item letter D, a presentation by Bureau of Indian Affairs of the federal regulations requirements. So at this time, I'd like to go ahead and yield the floor over to Mr. Greg Mahoja with Bureau of Indian Affairs. So *6 to unmute.
Thank you, Honorable Madam Chair, Honorable Vice Chair, honorable members of the Resources and Development Committee and others participating in the room. My name is Greg Mahoja. I'm the Regional Director for BIA Navajo Region. I apologize for not being there in person. Unfortunately, my schedule prohibited me from doing that. I do, however, have my team of subject matter experts there in person to participate and provide a presentation to further the goals of this meeting and to provide technical assistance and answer questions that come up after the presentation. So thank you very much. I will be listening in for a little bit, but then I have to get off. If there's anything more that I can provide, I would gladly do so, Honorable Madam Chair. And thank you very much for allowing us to participate in your meeting today.
I'd just like to thank you for that, Mr. Mahoja, and having your team be present here with us yesterday and today. So at this time, I'd like to go ahead and yield the floor over to United States Department of Interior Bureau of Indian Affairs, Mr. Sosi, Mr. Curley, for your presentation. And I believe you sent a PowerPoint, right, Hagushi? So Rodney, if we can go ahead and display that, Shona.
Thank you. Madam Chair, appreciate that introduction and the opportunity to present before this work group. I want to also thank the other Navajo leaders here, council honorable delegates, as well as folks in the audience here. Thank you for being here. is on it, the never Washington is on it, Washington never is on it by yet Hodi. Arun and Lee, one has on the the banner, so you're getting so. But the land missed up and that you did also that Nasta and did or if it no point in it. So again, I want to say thank you for giving us the opportunity here. We are going to make a presentation. Before we hand it over to our realty officer from the region, I want to ask DRDRVC if you have any comments on anything. Okay. Also, again, thanking RD Mahoja for being on the call, supporting our team here. I wanted to share a couple of remarks before I hand it over to Dina. Basically, yesterday we had some presentations from different tribal entities, and it was really enlightening to hear some of the process procedures that they use in looking at how an application might be processed. Again, I want to mention and put into context, well, at least from my understanding, what we're trying to do here yesterday and today. Really, it's about how a tribal consent process fits into the overall federal decision for right-of-way application. That's really my understanding as the crux of the situation here. Because if you want to get a right-of-way for ARPA funded projects,
you have to go through 25 CFR 169. That's the federal regulations that we use from the Bureau of Indian Affairs. And within that process, there's a set of requirements for an application. Normally at the beginning of that process, a realty team do meet with the applicant to train them and also to answer their questions. And Dina will talk a little more on some of the details of that. But we engage with the applicant up front in really looking at what the scope of the project is, the details, the length, all that information is really discussed at that point. So the applicant is then on their way to meet those requirements for documentations such as NEPA and other required items that we have to have. But within that also is consent of the landowner. And I mentioned this yesterday, that really we need to keep in mind two concepts here. The landowner, the nomination being the landowner for tribal trust lands, and then the land user. These are lessees or permittees, such as grazing permittees. Those are the land users. The regulation is very clear on that. And so really at the end of the day, from the federal side, we seek the consent of the landowner. That's what we seek for our application project, that it's required. But again, respecting the nomination sovereignty and the self-determination that they have, we do recognize the tribes have their own laws and regulations. And under that process, as we have been talking about yesterday, and I'm sure we'll talk about that today again, is how the permittee is part of that process. We really don't give guidance on that, except to say we do give guidance on the federal regulations. Okay, so with this, I want to turn it over to Dina Ness, our regional realty officer. She has a lot of wealth of experience. She came from a different region where they work on these types of different processes and procedures. So after that, I will just kind of summarize the information and be ready to answer questions. Dina.
Thank you. Sorry, I'm not used to using a mic. I usually talk really loud and don't use one. So if I get too loud, just let me know. Again, just want to say good morning. Thank you for inviting us to present on the 25 CFR requirements. Majorly talking about consents for rights of way and leasing. Next one. So today we're going to be covering 25 CFR Part 169 rights of way and Part 162 leases and permits. General topics that we're going to be covering are certain terms to know, when consents are required, and the tribal land consents and allotted land consents for each part because they do differ. To begin, we're going to start with 25 CFR Part 169 regarding the rights of way over Indian land. This part is intended to streamline the procedures and conditions under which we at BIA will consider requests to grant a right of way over and across tribal lands, individually owned lands, and BIA lands. This part is also intended to support tribal self-determination and self-governance by acknowledging and incorporating tribal law and policies in processing a request for a right of way across tribal lands, and to defer to the maximum extent possible to the Indian landowners' decisions regarding their Indian land. To start, I'd like to share a few key terms that we feel are important to know. For instance, Part 169 covers BIA land, which is lands held by the BIA that are not considered Indian land or tribal land. Also consent, which must be in written form for a specific action. Right away, please note that it directly states that title to the land remains vested in the landowner. We're going to go over that a little later. Tribal authorization, that's the way the tribe issues its consent over tribal land. Well, actually all lands. I wanted to include this because the definition states that it includes the surface estate of lands held in trust for a tribe, but is reserved for BIA administrative purposes. That's included in the definition of tribal land. This is the reason why BIA has interested parties go to the tribe for consent when they request usage of lands that are reserved for BIA. Based on the definition, BIA does not have the authority to grant permission without tribal approval first. Allotted lands or Indian land is individually owned land. Okay, so now we're on to when BIA or landowner consent, sorry, wrong one. When BIA consent and landowner consent is required. There's 3 instances where BIA and the landowner consent is required. This is when the applicant is not an owner of the land. The applicant is an owner, but owns a fractional interest, or the applicant is the tribe or legal entity owned by the tribe that owns a fractional interest. Even if they own a majority interest, they are required to have a right of way. When is BIA or landowner consent not required? The individual owns the land 100%, or the right of way is authorized under a separate lease. There is a tribal land assignment that authorizes use without secretarial approval, a tribe-specific authority, land use agreements not subject to Part 169. Example would be 25 CFR Part 84, encumbrances of tribal land. And there are some instances where we may require additional information, such as a parent or guardian who may then require evidence of a direct benefit to the minor child. And once the minor turns of age, they would be required to obtain a new right-of-way to authorize continued use. For the service lines, it must be filed with BIA. For the ones that are independent legal entities owned and operated by the tribe that owns 100% of the land. Oops, sorry. Would be completed by the tribal access authorization, which would then need to be submitted to BIA for recording. And finally, if authorized by law, then the applicant must be in compliance of the applicable laws. So what are the applicable laws? All requirements under Part 169, all applicable federal laws, and subject to tribal law, to the extent that the tribal laws are not inconsistent with applicable federal laws. Consents. Tribal land consent requirements must be in a written form and approved format as required by the tribe. A duly adopted tribal resolution, tribal ordinance, or other appropriate tribal document authorizing the specific action. We note that any restrictions or conditions become a part of the grant automatically. So if there's something in the resolution that is putting a restriction, it automatically becomes part of the grant, even if it's not written into the grant itself. For allotted land consent requirements, the applicant must notify all the landowners with a letter of intent and obtain written consent from the owners of the majority interest holders of each tract of land affected. It's not the number of people, it's the number of consent ownership owned by each individual. Again, any terms or conditions stipulated by the landowners must be agreed upon by the applicant and will become part of the grant. If the applicant does not agree with any stipulation or condition requested by the landowner, that will be deemed as a non-consenting owner. In certain instances, BIA can approve a grant without landowner consent, but all of the conditions must be met before we can do this. 1, the owners of the interest in the land are so numerous that it would be impractical to obtain consent. For this purpose, the number of landowners must be over 50 individual landowners. 2, we must determine that the grant will cause no substantial injury to the land or landowner based on certain factors, such as reasonable length of time, amount of acreage, disturbance to the land, the activity to be conducted, environmental or safety impacts, and most importantly, objections raised by the landowners. 3, we must ensure adequate compensation for consideration and any potential damages that may arise. And 4, we must provide notice to all landowners of our intent to grant the right-of-way at least 60 days prior to the grant and provide the landowners with 30 days to object. So who is authorized to give consent? The tribe, the adult Indian landowners, and if applicable, the life estate tenant and the remainder thereof. However, there are instances where another individual may consent on someone's behalf. The adult parent of a minor child who has legal custody, the guardian, conservator, or other fiduciary appointed by a court on behalf of an individual landowner. Individuals authorized to practice before the Department of Interior. BIA can consent as stated before, but BIA can also consent on behalf of the following: deceased landowners and their heirs and devisees that have not yet been determined, landowners whose whereabouts are unknown, individuals who are found to be non-compos mentis or determined to be an adult in need of assistance who does not have a guardian duly appointed. Also, an individual landowner who is an orphan minor and does not have a guardian, or an individual who has given BIA a written power of attorney to consent to a right-of-way across their land. Finally, an adult or legal entity who has been given a written power of attorney from the landowner that covers the authority to grant a right-of-way over or across their land. So again, like Mr. Sosa had said, for rights of way, there's nothing in our regulations that require us to get consent from a land user. Everything listed are land owners. So now moving on to 25 CFR Part 162 regarding leasing and permits. The part is intended to promote leasing on Indian land for housing, economic development, and other purposes under which we at BIA will consider a request to approve leases across tribal lands, individually owned lands, and BIA lands. It's also intended to tribal self-determination and self-governance by acknowledging and incorporating tribal law and policies and processing a request for a lease or permit on tribal lands and defer to the maximum extent possible to the Indian landowners' decisions regarding their Indian land. So again, there's pretty much the same key terms to know. So consent has the same, as it must be a written form for a specific action. The lease is a written contract between the landowner and the lessee. This document is particularly important as it could limit the landowner's right to possess the leased area. Example, issuing the right of way within the lease area without the lessee's consent. We can have it in the lease that the landowner retains the right to issue that without the lessee's consent. A permit is similar to a lease, but it's non-assignable, temporary, and a revocable privilege. And we see the tribal authorization. This is the way the tribe issues it consent. Oh, sorry. Thank you. All right, so permit similar to a lease, but it's not assignable, temporary, and revocable. We see the tribal authorization, which is the way the tribe issues its consent. Tribal land, again, I wanted to include this because it is the same as in rights of way, that it includes the surface estate of lands held in trust for a tribe, but is reserved for BIA administrative service purposes. So again, this is when we go back to the tribe and get their consent first, when anyone asks to use land that has a BIA reserve on it. Finally, there's tribal land assignment, which is a contract or agreement with tribal members or 100% owned tribal corporations that conveys any rights of use of the tribal lands in accordance with the tribal laws or customs. So when does a lease require BIA and landowner consent? Here we only have two instances. This would be when the applicant is not an owner of the land, or the applicant is a landowner but owns a fractional interest. When BIA or landowner consent is not required, this would be the individual owns the land 100%. There are some instances though where we may require additional information, again, such as a parent or guardian. We may then require evidence that it's a direct benefit to the minor child. And once the minor child turns of age, a new lease must be obtained to continue possession. If it's a 25 USC 477 corporate entity, which is now under 25 USC 5124, or the lease is issued under 25 USC 415E, then the documents would just be submitted to BIA for recordation. Note that 25 USC 415E leases do not follow these requirements under 162. What are the applicable laws that apply? All requirements under Part 162, applicable federal laws, and any specific federal statutory requirements that are not incorporated under 162. And they are also subject to tribal law. BIA will comply with tribal laws in making decisions regarding leasing, including regulating activities, land use, environmental protection, and historic or cultural preservation unless contrary to federal law. Consents, as like with right-of-ways, tribal land consent requirements for releases must be written in form in approved format as required by the tribe. A duly adopted tribal resolution, tribal ordinance, or other appropriate tribal document authorizing the specified action. Any restrictions or conditions become a part of the lease automatically. For allotted lands, consent is on a sliding scale depending on the number of individual interest owners. The fewer number of owners, the higher the percent required. If the applicant is a landowner, their consent is considered part of the percentage needed. Consent must be in written form. I know it's hard to see up there, but the sliding scale is on the slide there. So who is authorized to give that consent? Again, it's the tribe, the adult Indian landowners, emancipated minors. However, there are other instances where another individual may consent on someone's behalf. Again, it's the adult parent of a minor child who has legal custody, the guardian, conservator, or other fiduciary appointed by a court on behalf of an individual landowner. Individual is authorized to practice before the Department of Interior. And again, BIA can consent under certain circumstances, such as deceased landowners and their heirs and devices have not yet been determined. And landowners whose whereabouts are unknown, individuals who are found to be non-compos mentis or determined to be an adult in need of assistance, but does not have a guardian duly appointed. An Indian landowner who is orphan minor and who does not have a guardian appointed, or an individual who has given BIA a written power of attorney to consent to release their land. BIA can also consent for all Indian landowners if we have given the landowners written notice of our intent to consent on a lease on their behalf, and the landowners are unable to agree upon a lease during a 3-month negotiation period following the notice, and if the land is not being used by an individual landowner who owns 100% of the land. Finally, an adult or legal entity who has been given written power of attorney from the landowner that covers the authority to grant a lease over their land. So that was basically like the quick overview of our regulations that we follow. Any questions?
Thank you. Just a couple more comments briefly. In our experience at the agency at Eastern, I can't remember when there was compensation paid for public infrastructure. We've processed many rights-of-way applications. It is true on more the commercial side, and there's a pipeline company requesting a right-of-way. Certainly there's compensation involved in that. But for the public infrastructure applications such as the ARPA funded projects that we're talking about, normally there's a waiver of compensation. Just to one point I want to share with the committee here. The other point is on federal and tribal probates. So on the federal side, we only probate those federal trust assets, such as IIM accounts or ownership to an allotment. Beyond that, we do not do that. On the tribal side, of course, the probate involves, permits or leases and other things, home site leases and things like that. So we don't get involved in that. And then the family member, of course, would have to initiate the probate process there. I want to end by we've been at Eastern, we were talking about and discussing this internally. And we also vetted this with Ardeen Mahoja. we are going to present a letter to the land board that talks about consent. So I just want to read parts of the letter to you all here, just to help you look at this issue of consent. Dear land board members, this letter serves to provide guidance on if there is a requirement of obtaining Eastern Navajo Agency grazing permittees consent for rights-of-way applications or various purposes crossing the permitted areas within a range unit. The Eastern Navajo Agency grazing permit is the official form used for granting permission to permittees to graze livestock on the tracts of land included in the range unit for the permit. The permit is not a lease nor a title document and doesn't grant any ownership or leasehold rights to the permittee. Leasehold rights means all rights relating to a lease of certain real property set out in a leasehold agreement, such as a private home ownership lease. Since the permit is only for permission to graze livestock, it is subject to cancellation for various non-compliance with the terms stated in the permit. I want to draw your attention on this. This is on the permit that we issued. The permit contains an important provision. So every time we issue a permit, we have the conditions and the requirement of the permit, okay? This is signed by the permittee and us when we issue based on all the requirements, based on the conservation plan, all these different requirements that are there. So in that provision, it states this: access to and across Indian lands. It is understood and agreed that the authority is reserved to the secretary / regional director / superintendent to grant access to and across any of the lands covered by this permit as deemed in the best interest of the landowner, including the privilege of prospecting for and removal of oil, gas, and other minerals. Again, at the top of that sentence, that authority is reserved to the secretary. So this whole conversation is around, I don't know if it's even valid, I'm not sure. But I'm just reading what comes off the actual document that is agreed upon by the permittee and us when we issue a permit. Okay, so that would be my last comment. Thank you again. We stand for questions.
Mr. Sosi and Ms.
Yes.
Ness for your presentation on 25 CFR regulations. I think a lot of the individuals that are here have been pretty much some are well versed with these particular regulations since they are project pushers out there on Navajo Nation. So at this time, for time's sake, if anyone has questions, let's keep questions to just short and concise, you know, for Bureau of Indian Affairs here. As he just mentioned, the letter that he read out that is coming from Mr. Mahuja to, is it overall the grazing officials too and the land boards on eastern side?
So this letter was based on our conversations with land board and others on looking at consent for permittees. So that's how it evolved. And we developed that from eastern side, and we did vet it through RD Mahuja and others, but we feel we're on solid grounds in making that letter to the land board on eastern side. But it's on tribal trust land, so tribal trust goes across.
So this would be applicable to tribal trust oversight individuals who are the grazing officials, and then also to the permit holders out there on Big Navajo. So with that language provision that, or the provision that is stated in this letter, pretty much is self-explanatory as to what rights grazing permit holders have. It's just allowing permission for the individuals to graze, but any other in-depth or decision in regards to minerals or development, it sounds like it is reserved to the secretary, right?
So again, the permit is just really it's not a right in a sense. It's really just to permit for use of the land for grazing only. Nothing else. It has no other basis for any leasehold holding of any kind. If you look at, again, between difference between a lease and a permit, as Dina also explained, permits are terminable. We can terminate that. Leases, you can't, because it's very clear in there they have, the leasee has appeal rights as well.
Okay, thank you for that clarification. So I'd like to go ahead and allow anyone of the audience, in case you need some clarification or you have a question to pose to BIA here, and this is the prime opportunity to do so. So does anyone want to ask a question? Ms. Chair Maya.
Good morning. Morning, Mr. Sosi. Good morning, everybody. My name is Rowena Cheremaya. I'm the Director of Minerals Department. Mr. Sosi, I have a question of clarification for your comment on ARPA projects. I'm not sure I understood what you said. You said normally for ARPA projects, the BIA waives all compensation?
No, I didn't say that.
Okay,
Just to clarify, in our experience at the agency, every time we got an application for public infrastructure development, usually the applicant would approach those individuals that we require consent from. And we explain, I mean, through the applicant, they explain the requirement for compensation. And normally when that happened, they would say, this is what, let's say, a water line project, it's going to benefit this community, and really going to help overall the situation in addressing health issues or different things like that. When that's explained and the purpose and the scope of that project, the landowner, such as the allottees, will usually waive compensation. So it's for any public infrastructure projects. Now, if you look at ARPA, many of the ARPA projects are all public infrastructure projects benefiting the overall communities. So my sense is that the approach would be the same. So whoever's the applicant will go to the allottees or the non-nation and then explain to them that they do have the option of waiving compensation for that project. And it really makes a difference when the applicant clearly explains how the community is going to benefit. And I, in my experience, like I said, I have not seen one where the compensation had to be paid out for public infrastructure. For old pipelines, that's a whole different story. It's more in the commercial realm.
Did that clarify your question?
yes, it did. Thank you so much.
If I may add one other comment.
Okay,
We're working very closely with Calvin Castillo on these ARPA projects. So we're orienting them, we're explaining to them, engaging with them on these different aspects of a right-of-way application.
so before I yield the floor over to NTOA, let me go ahead and give it to our legal counsel, Ms. Khan.
Madam Chair. I just wanted to make sure that we are not getting confusing. We need clarification on the word compensation. We have two types of compensation that we have been discussing yesterday and we're starting today. What we're talking about, what Mr. Lester Sosi is talking about is payment for the right of way, which is waived in the certain circumstances that he has described with regard to allottees. And the Resources and Development Committee itself waives right-of-way payments in certain circumstances. That's a different situation than what we are talking about with the General Land Development Department and Land Department are working on with regard to consent of land users for the amount of compensation. And I know, unless you were here yesterday, that there is this distinction. So don't cloud the two. Right now, he's talking about compensation for the right of way, which the LRTs are allowed to ask for. Thank you.
Yeah, Ms. Khan, for that clarification. So yeah, the two distinction was pretty much overviewed by legal counsel yesterday. So right now, we are really just focusing and honing in on the ARPA project built out. And of course, we have the eastern side and the big Navajo to deal with. So let me give it back to BIA and I'll give it to you, Mr. Kuntz.
With all due respect, I appreciate it, the counselor's clarification there. But you got to remember, we're kind of in an interesting scenario here. Yes, it is true, as part of the regulation, there is a consent and that compensation can be part of that conversation. But the consent that we're talking is embedded into the tribal process, right? Where possibly an eminent domain could happen. But what the tribe is doing here is using a federal permit action to justify that part. So it's really tricky there because it's a federal permit, let's say for grazing permittee. And under the federal laws, the permittee is a user. So now you're embedding the consent process for application and you're using it as a basis for that. So I just want to tell you this interesting quandary we're in. And certainly the legal expert will have to look through that. But from our side, what I'm explaining is just the requirements on the federal side. Thank you.
Mr. Sosi. Okay, I'd like to go ahead and yield the floor over to Mr. Rex Kuntz with NTUA.
Thank you, Chairman and members of the RDC and everyone here. It's great dialogue. One of the most openness I've seen for all the participants on trying to find a way to meet the people's needs. I just wanted to say that. The question I had was, when you look at the 25 CFR 169, it talks about the requirements for tribal consent and landowner consent. Now, what I heard Mr. Sosi say was that the permit allows an activity, permitted activity, but not landowner rights. So based on that, the permittee is not a landowner, but a permittee, which kind of changes that dialogue. But I do understand that the nation may want to compensate still the user, the permittee, for the loss of the use of the property, which would be some form of compensation for the loss of the grazing. And, you know, what I'd like to state is, you know, we've talked about underground and overhead does not take away the grazing permit or the ability to graze. Once it's done, it's open. And I heard Mr. Alana say something similar yesterday. So it's just something for everyone to understand, but I wanted to clarify that real clearly, because that was always my understanding. That the permittee was permitted the ability to carry out the activity of grazing, but not necessarily have landowner rights. Similar to when someone gets a hunting permit, you can go on trust property and hunt, but it doesn't give you the right to deny anybody else or to be denied. So it's a permit. Thank you.
Mr. Coombs. So again, what was stated by Mr. Coop is differentiating the tribal consent versus landowner consent. So in this case, a grazing permit holder just has, I don't want to use the word the right, the privilege to utilize the land to graze their livestock per what is stated in the provision of how many sheep units or AUMs. And with the concentration here on the Navajo side is, again, as a land user, the recommendation here, and this would be something, you know, for legislative and leadership here to really understand is, you know, compensate, you know, the land users, because with this development that's coming up, which will be impacted or infringing on their land for X amount of years. depending on how the agreement is stated with the nation to whoever's going to be running the infrastructure line. We're taking that land away, and we're taking that vegetation, the acreage away. So with that, that's the recommendation that has been given by Intuit, but I believe he wanted a little bit more clarity. So Mr. Sosi, you want to go ahead and make a response to Mr. Coont's question or clarification?
Yes, Madam Chair. Again, I always try to go back to the concepts of a landowner versus a land user, right? And the tribe certainly, they have the prerogative in different transactions in providing consent related to tribal trust. Now, if you really narrow it down to grazing permits, we see it as a terminal document providing privilege. So it's a permit, not a lease. There are agricultural leases. That's a potential use that could be used. But if we were going to go down that avenue, then you have certainly conditions that would be agreed upon. There will be maybe a longer term for use of that land. And basically, if there was a adverse decision related to that lease, they have appeal rights. So they can go through that process. So I think, Mr. Kuntz, I think you're consistent with what we've been talking about in terms of what a permit is related to a grazing permit, okay? So I think we're consistent on that part.
Mr. Sosi, for your clarification. I do have Mr. Halona.
Thank you, Madam Chair, Vice Chairman, of the Resource Committee, and DOJ, Legislative, BIA, and everyone in the audience, colleagues. Mr. Sosi, I guess, from your perspective, BIA, who do you consider the landowner? Okay, who's the landowner? And I think once we get that clear, we know from kind of our side is the president and the council, the oversight committee, RDC, who oversee that and been delegated that by council. Okay, so, and then the other, mention what you mentioned as far as the federal government issuing the permits, was clearly states that they have a permission to use the land or based on the, I think the certain number that has been identified. So in that permittee, the land user, as we would see in an allotment, you know. So I think once we get those clear, then I think we can start moving forward and realizes that, okay, so where we've gotten to now, moving forward, based upon what we've learned, is the grazing permittee consent required before we do anything without moving forward on anything, home site, water line, utility lines, anything? Or is it only, and then anyway, that I'll leave it at that, and then I'll ask the questions more. But I think once we get that, will help us all just focus on that. And we kind of clear, I guess, the language like compensation and consideration. Now we can clear what those are and help us move forward. Thank you.
Mr. Sosi, you have the floor to make a response to Mr. Halona.
And thank you, Madam Chair. I think any of these policy discussions or looking at different processes and procedures related to federal regulations, it's always important to look back at the nomenclature or the terms that we use. You'll see in the regulation usually a section on definitions, right? So I want to thanks Stina for citing this for me. If you look at 162 up front, they have real clear definitions on these certain terms. So let me go ahead and start off with the Indian landowner. So it says Indian landowner means a tribe or individual Indian who owns an interest in the Indian land. So it's very clear. It's that in this case, the Navajo Nation on tribal trust. Now anybody else, the Navajo Nation. Then if you look at what a permit is, a permit means a written, non-assignable agreement between the Indian landowners, Navajo Nations, or BIA, and the permittee. whereby the permittee is granted a temporary revocable privilege to use Indian land or government land for a specified purpose. And that again is the definition of a permit. If you look at lease, it says lease means a written contract between Indian landowners, Navajo Nation, and a leasee, whereby the leasee is granted a right to possess Indian land for a specified purpose and duration or the term. The lessee's right to possess will limit the Indian landowner's right to possess the leased premises only to the extent provided in the lease. So there's a contract that from the landowner say, okay, we'll give you this to use it. And with under these conditions, under these terms, you Navajo Nation, you have a limited access in a sense to that based on what the lease agreement says. So again, that's what it basically through the definition says on here. Indian tribe means an Indian tribe under section 106, under the federally recognized Indian Tribe List Act of 1994. I know that's been updated annually too, based on different situations that happens, but just want to share that with you. That's what really some of those definitions, those terms mean. And it's always interesting to see folks try to navigate through those definitions, right? But we have to always come back to that core definition, what it means. And that because the regulations are built off those definitions. Thank you, Madam Chair.
Ogoshi, does that clarify your question, Mr. Halona? Ogoshi, yeah. Next to Mr. Larry Sosi.
Yeah, all the committees and legislation, RDC, DOJs. Question for you, Mr. Sosi. Larry Sosi, Shiato, last President official. You guys have one permit, and the permit's a federal document, and we're not the ownership of that federal document. How can you do a clarification on that? Because with one permit, how many is there that are holding it?
You are certainly right, Mr. Sosi. That grazing permit that we issue is vetted through OMB as an official form of the federal government. So we use that as the form for issuing grazing permits. What's been interesting in my experience at Eastern was that if you look at, for example, on Eastern, we have District 15, which is Northeast Hughes, White Rock, in that area, and Standing Rock. And I remember when I first came on board, gosh, 10 years ago now, with less white hair. But back then, we had a meeting with a tribal judge from Crown Point because there was an issue around probating grazing permits. And that tribal judge told us that we had nothing to do in probating this because it's a federal document. We can't oversee federal transactions, is what that judge told us. So it's always interesting to hear this conversation on at least District 15, that those permits are probatable and how that's processed through the courts, tribal courts. But that's what the judge told us. But anyway, that question certainly does, I think, provide the information that is a federal document that we use to issue the permit. And of course, it has the conditions clearly laid out on that permit as well. Of course, it also has the AUM listed on there for allocating AUMs for each permittee. Madam Chair.
Ogoshi, yeah, although Mr. Sosi for your presentation from BIA. Again, this is just to give you an overview of, again, Bureau of Indian Affairs works closely with the Indian allotments, the allottees that we call there. And these allottees also hold grazing permits there. Although they oversee the grazing permit on Navajo Trust, right? You issue them?
Madam Chair, for Eastern side, when we go through our grazing renewal process, we do look at Indian allotments. And so we work closely with the land board. If there's an allotment that's identified within that range unit, Then we work with the allottees, the owners, under what we call authority to grant program. So we seek permission from those owners to make this allotment part of that range unit. So we go through a very formal process. We have 90 days to get their consent. And when majority consent is provided within that 90 days, then we inform the land board that that allotment is now part of the range unit. But on our side, then we go into our system to make sure that we encode it and the grazing permittee pays through our process, and we funnel those benefits back to the allottees. So that's kind of how it works through the TAM system that we have. We go through the invoicing and all that type of process. So they do benefit from that on allotment lands. Certainly, there's also tribal trust land that we work with the Navajo Nation on that part. Then we also have government lands in Eastern. So those funds, we also do invoice for those lands, and that's paid back to the US Treasury. Thank you.
Mr. Sosi. So with that, for attendees present here, does anyone have any additional questions or any questions at this time? The gentleman in the red. Could you please state your name, Ashonda?
Philip Zani in Shia. Coal Mine Canyon Community there, next to Zosto. I didn't know shut. So, just on the clear on, Shido, Victoria Dashijedo, Sinajili Dashichedo, that's also by the lunch. I just thank you for the opportunity to allow individuals to make comments. RBC members, chair, no voice, a lot of members on the audience, and representative from different agencies, organization, or this whole thing. When we get down to PIA jurisdiction, tribal jurisdiction, it gets confusing, especially when you get down at the local level. The chapter has most of the time, what I experience is that the lack of education, the lack of knowledge at that level, it is assumed whether the project's on trust land or BIA land or allotment land, you get all these different land status that you get involved with at local levels. And when various projects are proposed on these different land status, so once a chapter, it is said that once a chapter resolutions recommends to either go or to go forward, it is said that once the chapter or the local community says no, but still the opportunity is still there to go through the channels, the 164 process for land use. Once it starts happening, different levels, different agencies make those comments. Who really has jurisdictions? Who really is a go process or a no process? Different land status. I think that the tribal trustee, it goes to RDC with the ultimate, with the president's signature, yeah, it does get confusing. So, so sometimes, even though I understand, even though there's a no, because of DOJ may say in the best interest of the nation, the best interest of the community or the people, it's still a go. So I can see you see because of different land status, there are small community projects that happen. Although there's big projects, even though some of these communities are way far away from Window Rock, but these major projects
or conceive at this window rock level. Other hajot the Nebasana, other hajot the deep project behind ego, other the last lead happening. So eight ego. So it is confusing to the public. So I'm trying to narrow it down. The other question that I have is farm permits, agricultural use. I understand, and somebody said, chapter double hot nita. The HPRA ban Ajabia, la Shijak, PRA ban is chapter 8 of what that over that in these situations. But nigga, so you got these different opinions, what people think. So because of that, and because of the lack of legal assistance given to chapters, it makes it complicated for somebody to stay in touch with them at the local level on some of these issues. Well, I think I don't know if you understood what I'm trying to ask. So, this opportunity again.
Mr. Zani, right? And they call Mine Canyon chapter. So the question here, and I believe, I don't know, Mr. Halona, if this would be pretty much directed to you to make a response. And this was one of the topics in yesterday's dialogue that we had, where the grazing permit holders can't really say yes or no to a project development, yeah. And then public infrastructure go bahaodzi and going forward, and the gentleman here mentioned that they have a chapter resolution either to support or oppose the project. But in the circumstances where the project is being opposed by a chapter resolution, but this particular project at a larger scale is going to benefit, community members, where Windsor Rock is pretty much making the decisions to go with these certain projects. Like, as a local municipality, a local government at the chapter level, do they have that? And this would also probably be a question for Division of Community Development through Title 26. And projects, I guess you proceed with the project, so no chapter opposes it. I don't know if you want to go ahead and make that response, because I know we kind of touched up on this yesterday. Ada, with the experience that you've had while you were at Land Department in collaboration with other divisions, I'll go ahead and allow you to make a response to the gentleman's question here.
I don't know. I think every time I turn around, there's more people. That's good. I guess we'll just get right to the point. If the chapter does not provide a support resolution, does it kill the project? According to the land withdrawal designation regulations, I think it was clear yesterday, that's one of the requirements is to get a support resolution. So what we've looked at in the past is, okay, if they don't give you a support resolution, how many times should you go back and request it? To show that you attempted, okay, in good faith. How many times are you going to do that? And we know that project is very important. And that's what causes chapter boundary situations. Because I kind of think it's was it the project over in Curry Valley? Okay, somehow I know that anyway. But it happens to be it's proposed to be developed in one chapter. And
Upstream is the other chapter who's going to probably get a majority of the benefit from it. Ako kagit kanya you know, we don't want to approve it because they're going to get it. What's in for us? How come we don't get anything? So moving forward, I guess there's two ways I'd recommend anyway. One would be perhaps we revisit the land withdrawal designation regulations of 2015 and change some things. I can tell you, we put that together kind of quickly to help New Mexico chapters, because all of this money is going back to the state. And so they want site control. To get those funds from the state, they needed site control. That's why we came up with the land withdrawal designation. Land withdrawal is a term that is developed on Navajo. If you look in the CFR, you won't find land withdrawal type. Land withdrawal. And so we put it in there where it's a real quick, fast process where they can get kind of a zoned area for 5 years. That gives them site control to get the money and then do the environmentals needed to get that project developed. That, and then to fix the land withdrawal, because you still have a chapter pull out a survey plat. This was withdrawn, 10 acres. So where's the rest of the documents? Resolution at 10. Or they have a resolution, but they can't agree where the 10 acres was. And there was no sunset on them. So we went to resource committee and we told them, these are the challenges we're having with withdrawal. New Mexico, so that's how we came up with the land withdrawal designation, thinking every chapter is concerned about their community and their people. They'll support every project. Well, it hasn't been happening that way. So that would be one. The second would probably be keep moving the project through the process. And when we get to the part where we need to get to start, okay, to issue that lease to the applicant, we can bring it to RDC. They can make the decision on that chapter support resolution. They're the ones that develop those regulations. In this situation, this project, we waive that support resolution. Has on it, any door that you like, no constant on the door, avocado may not or like not for dollars. That would be my recommendation, those two. Probably coming to bring in that project before RDC, just like a waiver. If they want a waiver, they come to RDC. They want to change in the amount, they come to RDC. The land department does have given some authority, and if there's no negotiations, no different requests, they're signing it and they're done. But if they want special provisions, then it has to come back to RDC and they make those provisions. That would be what I would recommend, Chair. Thank you.
Question here, Mr. Halona. So again, that's going to be added to our to-do task under policy amendments and changes. Hajoon linigi sad e agenda kasi dahan bihindo so chukade linigi to e hazenda. So with that, I don't know if we have any more questions. Let me go ahead and yield the floor over to Mr. Sosi, and then we'll come back to you. So real quickly, we are already headed towards 12, and we are supposed to conclude this session today by 3 o'clock. So Ashon, get to the question that you want to ask so that we can make responses to you. Yeah.
Thank you, Madam Chair and members of the committee and all those that are here. I'm Leonard Sosi. I'm with Eastern Navajo Land Commission Office. The concern and question I have is just from an experience, is that we have a big project in the Eastern Agency, the water project, and it's being held up by one permittee. This is going to benefit thousands of homes, and it'll benefit economic development at all those chapters. And so it's really been troublesome. And my worry is that BOR, we're working with BOR, US Bureau of Reclamation. At a certain point, they might say, enough of this, we're going home. And they'll take their millions of dollars home. And so what I would recommend as part of the policy changes is if the Navajo Nation Council can give the authority to the president to approve certain things, and where it's regional in scope, we cannot have one permittee holding up $1 billion project. Just can't do it because it hurts the chapters. Crown Point can't develop. Smith Lake is continue to drink radioactive water, all because of this one permittee. And we have the money now and everything to do everything, and yet, we have one permittee. And so the people that are helping us saying, what do we do? And because of all these dubious regulations or dubious interpretations of regulation, so we should just make it clear to give the president the authority to sign off on these things where it's regional in scope. And the same thing with like the Wi-Fi towers. The Wi-Fi tower, we have all these dark zones. And if the president, if it's going to be across the Navajo Nation, the president should have the authority to sign off on it. And that way, all these Wi-Fi towers will be built. You cannot have one permittee say no to a 50 by 50 feet space, and then all of a sudden, the children can't get it, the businesses can't get it, Wi-Fi communication, and then the police can't get it, all because of one permittee. And we shouldn't be operating like that. Because Eastern Navajo Land Commission is also for economic development in our regulations and in the law. And so we end up having to just stop because of these things. I think the preference should be for economic development, socioeconomic development, like water line and other things for the benefit of the people. And, just having one person hold up everything is very troublesome. So as part of the policy change, we would like to recommend that. Thank you.
Hakoshi, Asheha, Adoshanat Ani, Delegate Leonard Sosi for your recommendation, and we'll definitely, have it noted. I'd like to go back to the gentleman and just pose your quick question in response to what Mr. Halona had made, because we're pressed against time. We want to go on to the next presentation.
Hello, my question I have is the question I had on agricultural permits or leases. Actually, and also from the BIA, with the relations with the tribal authority. And then you enter the grazing representative again. The process involved, so it comes back all to the development of project for public infrastructure.
Hakoshi, Asheha. So I'm going to go ahead and defer the question to Mr. Lester Sosi.
I was just going to add some closing comments, but.
Okay, so he posed a question in regards to agricultural and
Oh, yes.
grazing.
So from the Bureau of Indian Affairs, we do have agricultural leases and also permits that we issue related to farms for grazing and other natural use, land use. So I think, as you guys all are probably aware, that there's been lots of discussions around grazing as well as farm leases. And I know that our team has been working with, I think, RDC and other committees to work out some of those key issues on those farm permits and leases that are out there. So we'll continue to work with certainly Navajo leadership, as well as those leases and permittees out there related to that. So that's my general comment back. I know it's not very detailed, but certainly we have our staff. If you have a specific question on a specific farm permit or lease, we can give you details on that part. But if I may do closing, unless you want to.
Hakoshi, so this really isn't in the scope of what we're discussing here today. We need to keep it focused on consent. That would be a dialogue for another day with RDC. Again, we are pressed against time. So if you could go ahead and make your closing remarks, Mr. Sosi, we'll go ahead and go on to the next presentation item on the agenda.
Okay, thank you very much. Hopefully today we've laid out the key areas, key concepts to use in making your decision or your analysis. Really, everything's laid out in the federal regulation 25 CFR that we use for 169, which is rights of ways, 162, even 167, the Navajo permit grazing regulation. So keep in mind land user versus land owner. That's a key concept to think about and use that. And there really is no requirement to get a land user's consent on many of these areas. So I want to mention that. I have not, again, I want to emphasize, I have not seen from us where for public infrastructure, there was compensation paid for that, even on the allotment side. So I just want to emphasize that once you set precedents, precedents will be forever, basically. So just be mindful of that. Again, there's different land status that even on Big Navajo side, and especially on the eastern side, we have to always balance and look at those regulations and tribal law as well to look at that. And then this last comment, changes to the regulations cannot be made at a local level. We would have to go back to the secretary on anything. So this notion of a policy change that certainly can happen on the tribal side, but not on the federal side. We would have to work with the secretary. Those of you I want to recognize our team, Cheryl, the deputy here, as well as Dina, for helping us today. So just thank you very much, Madam Chair.
Thank you, Mr. Sosi, to you and your team for being present here with us yesterday and today. So going on to the next item on the agenda, we've also have the next task that we've kind of outlined in regards to the dialogue that just happened. The next presentation, so if you have your agenda, letter E, we're supposed to have a presentation on the Land Acquisition Trust Fund. Office of the Controller being very pressed for time because we are at budget season and we have comprehensive budget that needs to be prepared. So we're going to go ahead and skip over Office of the Controller's presentation on the Land Acquisition Trust Fund presentation and go on to letter F. Here, we have a presentation on issues related on obtaining the land user's consent for business site and home site leases and right of way. Now, as we had this dialogue, I think we've got, and these are again, just related to ARPA projects, but going forward, the long-term project development, SIGI, that's where Title 16 is going to be amended. But under this area yesterday, and I've also showed that here on this table earlier, is that home site leases. That is going to be a temporary, I guess, language provision or legislation that RDC will be dropping with the assistance of DNR and Navajo Nation Land Department, which they even committed to the deadline date of September the 23rd, right, Mr. Halona? HCA audit's going to streamline the home site requests right now to get these ARPA projects built up, especially if we had, you know, individuals, a lot of our constituents residing on this land. So yesterday's dialogue was that the chapter grazing official land board will just put in writing that this individual has been living on this land for X amount of years. and get that consent to evidence that. And then the disturbing of the land has already happened. NEPA, you got Fish and Wildlife and HPD, but I'm hoping that this would be an internal department dialogue, Mr. Halona, so that one department or even EPA won't say that, well, we didn't know about this, but it would have to be a collective dialogue before that legislation is requested to be dropped by members of Resources and Development Committee, Ishta. Now, with the business site lease area, do we have anyone from economic development here? I believe we don't. And then in regards to rights of way, so at this time, I'd like to go ahead and give it to Mr. Halona for this presentation. I don't know if you have any areas that needs to be addressed in regards to right of ways from Division of Natural Resources that you've all been, that has been coming to your desk, so that we could go ahead and hopefully streamline, or what we have here, is that considered something to rectify the current issue that is before us to get these projects built out? So, Paike, I'm gonna put you on the spot. It seems like you weren't prepared for it. I am really sorry, but it has Department of Agriculture and Division of Natural Resources as presenters.
Let me see. Which hat shall I put on to do this presentation? Again, good morning, everyone. I guess, I think yesterday, we were using some terminology that may have confused individuals, like rights of way. What BIA covered on the 169 are for right of ways, okay? And on Navajo, those are non-Navajo entity applicants. So for Eastern, you have Continental Divide, Amos Electric, Farmington Electric, Sacred Winds, Cell One, Verizon, T-Mobile, all of those non-Navajo entities, they follow rights of way process that BIA mentioned today. Yeah, what that? We took a part of the 169 out for TAAs, is the new term that we've been using now since I think 2019. We started the TAA before CARES Act happened, before the pandemic. We RDC was already had the finalized portion, and then of course everything shut down, and then about halfway through, RDC still acted on it and passed the TAA regulations. Those are for all Navajo Nation entities, NTUA, NECA, NDOT, NHA. All the chapters that they were going to do a TAA, they followed that process without BIA approval. Okay, all those TAAs used to come to RDC for approval. But for CARES Act, what we did at the end of the 24th council, we did the one-stop shop legislation that speeded up that process. So that's why RDC on their weekly meetings do not have all these projects coming to them for approval. Okay, so the only one that they're going to get are the right-of-ways that go to BIA for approval. RDC consents to those projects on behalf of the Navajo Nation, and then they go to BIA for them to grant them the right of way. And Hikwaja, Navajo Nation, the RDC gave that authority to the land department. But everything still goes through general land development department.
which is the entity that processes the consents, make sure all the consents are there for a project. The legal survey is there, the support resolution is there, the archaeological survey is done, the biological survey is done. Once those are all compiled, they put it into electronic system. So that's where we speed up the process. Previously, every project, permits, leases, rights of ways, all of them used to go to RDC. So when a packet comes in that thick, okay, the 164, we still hear that number, 164 process, we used to give it to the first department. They go through that whole aspects. Out of the then the mailman used to come to the office, take that packet, and then bring it to the next department. Whenever they're done, they pick it up. Every department, including DOJ at the end, reviews that packet. That was the 164. Some of you have been here long enough to remember the SAS process, right? So that we took that process and we said how, and it's streamlined. I think the General Land Development showed that that flow chart yesterday. Oh, so we said, why do we wait? And that old flow chart, what was interesting was the consent was the very last thing you did. You had to go through all your legal surveys, do your EAs, you had to complete all those first, and then try to go get your consent. All that money spent. So back in 2009, I think it was 2009, we switched it. We put consent up front so they would know, do we have a project moving forward or not before we spend any money. Okay, so that process was changed. Somewhere it would get lost. Somebody took out some document, didn't put it back in. It gets down here to EPA. They said, where's the map? There's no map in here. They have to go back and try to find who took the map out. Call the applicant, can you bring us a copy of the map again, reinsert it and continue. That's what those scary stories that people hear about. It took 7 years, it took 10 years. That's what happened. Yeah, it used to happen. Okay, so when that was changed, we said the TAA is what we want to go to. In 2016, the Secretary of Interior had gave the nation opportunity to comment on proposed changes in the right-of-way to 169. Of course, our comment was, give us the authority to approve our own rights-of-ways. So we didn't get it, but they gave us TAA. You can for the land that you own, and the entity must be 100% tribally owned. You don't need that's where the TAA came from. We used that and started developing those regulations with RDC. So the first one, of course, is consent. And then the chapter resolution, the legal survey, the biological, cultural aspects of it. And then they move forward. So what we did then was, how do we speed up this process? We went to electronic process. We said, what we'll do with this big packet, we're just going to scan it and we'll send it out electronically. But everybody is going to get it at the exact same time so they can start their review. It sounds very simple, but I can tell you it took almost 2 years to get it moving. Those things and it was hard to go from paper to digital. The maps are too small. We can't see, we can't open it up and you name it. My laptop is like this and I don't have that software. And my internet, 2 years when finally they started. Okay, now it changed again. When we tried the one-stop shop at that time, we thought we were gonna put all these reviewers into one building over here in this office in the corner. That way it comes in, they all sit down, they go through it, make their determinations, recommendations, or whatever. At the end of the day, that project should come out approved. That was the thinking. You know, I had to be at my office, I have all my data over there. We couldn't pool everybody together to start a new system. So after CARES, we had the taste of the electronic process already. So they said, we want to go back to that concept of one-stop shop. So we said, we already have it, it's electronically, but set up a plan of operation for it, set up the procedures for it. So we were given a deadline. RDC said, get that one-stop shop done. So that's what we did. And so when we went ahead and got everybody back together and said, this is what we're doing. Let's revise the flow chart, because after it went through everybody, then it went to DOJ manually. And then it went to the president's office for review. And then it went to legislative council for review. And then it went to RDC. And then it went back over here to the president's office before it went out. So we said, there's 5 legal reviews in there. Can we narrow it down to 1? And DOJ says, I think we can. They're on it electronically now. But when I go, everybody, and then how do we speed it up? RDC said, we're gonna put that timeline on there. 10 days. Every reviewer has 10 days. And if they don't review it, shame on them, because it's approved, we're moving, we're not waiting. So that's what we're doing with the one-stop shop, the TAA process. The right-of-way still goes through that process for CARES Act. So what they did was then they said, once that packet comes in, is loaded up, it's sent to all the reviewers. They have 10 days. The legal review is done. They develop this lease or the permit, terms and conditions, everything is done. Mineral says this is the assessment. If there's one, everything's done. Then it goes back. Land department was given that authority to sign it. It's finished. It didn't go backwards again. So that's the process that you have. So RDC, you don't see all those projects that are coming in anymore. It's finished at the land department. The director there signs off on behalf of what we used to do. And then the lease goes up to the president signs it and it goes out. So those are some of the changes that happened just within the last 10 years for the same reason. How do we speed this up? And I think with RDC, with all the departments, everybody working within DNR, we have streamlined it very well up to this point now. But it's only good up to 2026 is the deadline. After that date, it goes back to the regular process, RDC and everybody else. Okay, so that's kind of what we're working on to improve, and it is working well. But the only part is consents, because that's the front end of their project. So it's holding it up. Over here, we got 10 days to get this out. Over there's no deadline. So if we determine that consents are still required from a grazing permittee, we need to put a deadline. They have 5 days to consent. Yes, no. You know, some say 24 hours. That's it. Yes or no. And it keeps moving. It shouldn't stall. It shouldn't stop. Would be one recommendation as we are discussing the leasing, the consenting process. That's something that would really speed up
all projects, home site leasing, all the challenges that we hear about from our constituents. So I hope I provided right information.
Hakoshi, yeah. I do have Department of Agriculture and I do apologize. Mr. Ray Castillo is here to present and he does have a PowerPoint presentation. So Mr. Castillo, Hakoshi, so Honorable Danny Simpson has a question.
Thank you, Madam Chair, members of RDC, good morning, staff, it's okay here. Mr. Long, thank you for your presentation. And this TAA by UNTA, it's good for Big Navajo.
No, that's it.
And it's good for tribal entities, like ETA, UNTA. Going back to Eastern checkerboard area, it can help us in a certain way. D by UNTA is just not. I think we're looking to even Mr. Sosi be here, superintendent. I think we all need to come together to how we address the tribe, which BLM was here, and BIA, and also state other entities that what we have to go through to get a rights way for any type of infrastructure like power line, water line, data. So very simple of what you present is very good. I like that for Big Navajo, get power line, water line, these type of instructions for our people on the Big Navajo side, and especially working with the tribal entity. KJ could by entity, we've been caught in the divide, even though this our power line might be just going through trust land. You didn't mention how you're going to work with non-entities. With Continental Divide, Hamas, City of Farmington, Socorro, 80 Ada, 15 Ada. You mostly talk on the Big Navajo side and tribal entity. But over here, we're different. And you know that I don't need to educate people on that data on the checkerboard side. So how are you going to help us working with these non-tribal entities if the power line is just going through Navajo Trust Land? And one of our areas, like Yizan, you see that it can be broken down to phases, but we still have, it's just as phase 8 because we put all together, it's going to be going through BLM, it's going to go through a lot of land, it's going through, I think, state, but certain areas to certain people, it just goes to trust land. And you'll be going to working with Hamas down there to co-op data. So I'm not sure if TAA that you're talking about can work with just to try to work with that power line that's be going to trust land that's concerned, I think like 25 people. Like I said, we go out, we start going through BLM. So how can we work the way you present the way you present it, which is mostly on Big Navajo, the tribal entity, could you? Again, BIA is here. We don't have BLM, we don't have a state. How do we work together? Because a lot of these projects in Eastern are refunded by ARPA. And right now, we haven't heard how BIA can help us. They just get this dispelled out on how the process works. That's it. What authority does the regional director have? What authority does the superintendent have to help us out to expedite some of these projects where we get consent on these through allotment lands? If it's going to go to, it's going to be across allotment lands, or it's going to get to residential areas on allotment lands, residential leases. So DBL is the same way. That's a long process again. So anybody still, I just have a concern how we can work those things out. It's good, this TA, how you guys worked it out back in 2019, but I just need some clarification how even BIA, how can you help us and the tribe can help us on Eastern land? Anyway, I say, Madam Chair, thank you.
Honorable Simpson, in regards to question posed to Mr. Holon and also the Bureau of Indian Affairs in regards to the Eastern ARPA projects. Again, there has been an overview that was given by Bureau of Indian Affairs in regards to 25 CFR that BIA utilizes as a due process for these projects to be built out. And then Mr. Halona, in regards to the eastern side, working with the non-native tribal companies, how is Navajo Nation working with them to get these projects built out as well. So before I yield the floor over to Mr. Castillo, Mr. Halona, do you want to go ahead and make that response to Delegate Simpson's question? And then also to Mr. Sosi with BIA.
Stand by my brother over here, and that way he can help me answer it. Okay, no, I don't identify Delegate Simpson, though, Resource Committee, honest. And I was just amazed last night that we're having this dialogue, and it's something that we wanted.
Real quickly, I'm sorry to interject, Mr. Halona, but I just want to let everyone know we're going to, so lunch is going to be served. We want to also do a working lunch. So if you can just stay around, if you want to break for lunch, if you were thinking of having lunch off campus, please remain here as we're going to be serving lunch. Yeah. Back to you, Mr. Halona.
Okay, thank you. Delegate Simpson, what we've done in the past, working with project development, the applicant, if they reach out, and again, it's sometimes the applicant is developing a project, and until they hit that snag, then they may come in searching for assistance. And the assistance we've been providing in the past is to find out what their project is, where it's at, and do they have a preliminary line of, maybe it's a water line or utility line. Where's it at? Where's it start? Where's it finish at? Based on that information, they share with us, and then we overlay it on our land status map. And then we're able to tell them, this part here is trust land. And then you hit 2 allotments, and then you go into BLM, and then you come back out here on trust land. So here's the process that you would follow for the Navajo Nation trust land. For the allotments, you talk to Mr. Sosi and his team. BLM, you'd have to go to BLM and apply through their right-of-way application process. I don't know if that has changed, but many times we've asked all of the departments under the Department of Interior that they should just have one processing. Because in the past, you fulfill the requirements under 169, but under BLM, they want some additional things done or done a certain way or certain areas addressed. So they don't accept the work that was done for for the 169 on BLM land. And however long that takes, although we can keep following up. It's on their time. Same thing with the state. State will say, they got to come in, they got to bring this, they got to pay for this application, then they got to do this. Then you follow that process. Yes, it's a huge challenge over there to do some of these linear projects where they're miles, fiber, same thing with utility lines, water lines running more than a mile. And that's because the land status changes. And so some applicants have tried to get creative and figure, how do we go around them? Go this way, we could do this way, and then go back down. So they wait. What was that going to take time-wise? How much money are we going to lose waiting for BLM or just that added cost? Do we come out okay by going around them? And those are some of the challenges that they deal with. Could there be 1 or 2 grazing permittees, but once you hit the allotment, who knows how many allottees you have there? And then in this process, Chairman, Madam Chair, at some point, maybe we could have some of the right-of-way agents kind of give us what they're experiencing out there, because they're the ones talk about boots on the ground that's going up, knocking on the door, you know, explaining what they're there for, what their job is, and how is it that some of these guys have the ability to get those consents, sometimes where other times, other right-of-way agents weren't able to get the consents. Some of the things that the companies are doing now, they're just mailing out consent forms. They're trying to speed up that process timeline. They think we'll just mail it out. They'll get it, people will read it, and then they're gonna sign it, they're gonna send it back to me. That ain't gonna happen, you know, especially if I'm a lottie, I only check my mail once a month, so. You know, you've already lost a month, you're waiting on me. So those are some of the things that are happening. So when the land department started reducing the budget and people, NTUA was given that ability to get their own right-of-way consents, TAA consents. Okay, so that's something that we have come, that's the point we got to doing that. So back to Delegate Simpson's question. That's how we've helped applicants in the past to try to help them speed up. Because we've had some transmission companies now asking, you know, we need to know what we're getting into here. What's the land status ahead of time? So they can put it in their plan and know what they need to do. So they're gonna have somebody developing a right of way for state land, for BLM land, for trust lands, for allotment lands, and 2198 lands still gotta go through BIA as well. So with that, and it's a challenge. And I don't think we have a process unless the other parties come to the table like this and say, this is what we can do. This is how we can change things. That's the other part. Maybe step 2 we would take is have those entities meet us in Eastern and find out what they can do to speed up the process. I don't know if there's any congressional or presidential directives that have been made. Maybe Mr. Stokesy can talk about that to some of those other agencies. Thank you.
Real quickly, Mr. Sosi, let me go ahead and yield the floor back over to Honorable Simpson.
Thank you, Madam Chair. Thank you, Mr. Halona, for your response. I just speaking on behalf of 31 chapters of what we go through to try to get right-of-way approval for our projects within Eastern. It's a very complicated, complex, like you stated, and the reason why I brought up BIA too in their presentation, I believe what was stated, certain circumstances, consent on behalf of landowner, BIA under certain circumstances was mentioned, and the circumstances were not mentioned. What kind of circumstances can BIA consent on behalf of landowner? So that's one question. Then going back to, I think we're not really addressing how we can help Eastern Agency chapters to get these power lines, these infrastructures in place. So I know we're in a time crunch here within another, I think, 12 months. Before Mr. Sosi does give his response back, I'd like to ask BIA, working with Mr. Lona, to maybe get a meeting together with BLM, BIA, state, Navajo Nation, and set a meeting with RDC in maybe somewhere in Crown Point to discuss how we can help the 31 chapters to expedite some of these projects. And again, I wish this was done a couple of years ago when ARPA funds came in to start working how we can help Eastern AC. I mean, we're on time crunch. Hopefully we can get some of these projects obligated by September 30, 2024. So make sure that I want to make sure that these our Navajo people on Eastern AC receives the power line, water line, these infrastructure broadband, just like our relatives in Big Navajo with one land status. I'm gonna still be very vocal about it. So, Madam Chair, that would be my request to BIA to work with, Mr. Halona, Division of Natural Resources and Land Department to schedule a meeting with all these entities and see how we can help. And it needs to be done right away. One more question, Madam Chair. Mr. Halona, before Mr. Superintendent Sosi makes a response, since this TA expires, and I mean, but how it's working right now for Big Navajo and for ARPA funds to 2026, and I believe it's the Division of Land Department or Division of Natural Resources has a final authority. So basically, is NTA paying the rights of way fee, or is it already waived for them? Because I know on Eastern, our providers there, they ask for waivers, which has to go back to RDC. So if you have the final authority and there's rights way be waived already, that's already in place for this ARPA fund, is that in place already for HEA? These fees that's supposed to be paid for rights way, are they waived? Madam Chair, that'll be my question. I know you want to move on quickly, so this is just my question. Thank you.
Honorable Simpson, for your question. So with that, there is a recommendation, and I think this needs to be an immediate meeting request that would have to be collaboration with BIA and Navajo Nation to have BLM and also state and other stakeholders that own these particular land statuses in the checkerboard area for Eastern Navajo, because as Honorable Simpson mentioned, we need to get these project bills, because again, we have to remember that these ARPA dollars are to get these services to our people. So in such time that should another pandemic happen, we won't be at square A, but hopefully have these particular basic necessity services in the households of our families. So the next question after that, in regards to NTUA right-of-way fee, you want to go ahead and make your response to that, Mr. Halona?
Thank you, Madam Chair and Delegate Simpson, Resource Development Committee. Appreciate that question. In the TAA delegation, there are, as BIA mentioned, there are some public facilities that are going to receive services. So we say government, schools, hospitals, if that service is going to go benefit them, we don't assess a right-of-way fee for them. But if that service is going to oil well, gas line, cell tower, or base of any commercial use, then we assess a fee. Okay, we don't always get paid, but we assess a fee. A waiver, land department wasn't given that authority to waive anything. If an assessment is done and they agree to that assessment, oh, we'll go ahead and pay that automatically, then it's approved. So then they have to come to RDC. Waive, shall I say no? They'll come to RDC. Then you guys decide a reduced rate or waive or even higher rate than what's assessed. RDC what's a lot of. So for those commercial applications, okay. Now, when you look at E-rate money that came out and ARPA, there are provisions in those funding to pay rental and leases. It states it in there. Okay, so the nation could assess a right-of-way fee. So, so that's kind of where we are. So any changes from the process will come to RDC. All land department is follow the regulations, and if everything is agreeable, they sign it. Change it now, or asking something different from those regulations, then it's RDC that gives that. But it's been very tough to receive compensation for commercial use or a cell tower use. Now, there's been no payments made. They're out there and we just basically. Thank you.
Mr. Holonas, Honorable Simpson, did it clarify your question in regards to?
Power lines, water lines, electric power lines. There's a BGA. That's why there's a required procedure.
No.
I'm gonna go ahead and yield the floor over because I know Honorable Simpson had a question for BIA. Mr. Sosi?
Thank you, Madam Chair. I'm gonna try my darndest to be succinct and clear here. Honorable Simpson, thank you for that question. I really look to you for the wisdom when we're talking about these type of discussions, because you look out for the landowners and the different technical information that we have to work through. Based on practical experience from the Bureau of Indian Affairs, we have to always look at the regulations, make sure that we are addressing all those properly. So when the CARES Act happened, do you guys remember when that was, like a few years ago? So we got some significant funding from the CARES Act, right? So that was for us an interesting opportunity to look at how do we address these proposals, these plans for infrastructure development and other types of initiatives from the Navajo Nation. What we did from the Bureau of Indian Affairs internally is this, and I think this can be an example of success. Honorable Delegate Simpson, we implemented a team internally, what we call an immediate action team. Cheryl Curley really helped us and myself, we were co-leading on that team. What we did was we brought in all the key subject matter experts. We brought them to one table and we met maybe like every 2 weeks because we didn't want to be the delay from the Bureau of Indian Affairs. When the Navajo Nation was, going through all these different project development, we said, we're going to be there. We're going to have answers. We're going to address those setbacks and challenges. And not even minding the land status. Okay. So we had realty side, our subject matter experts came from there, natural resources, forestry, leadership, and then transportation was even, water was there. So we had all these experts there, and we gave them a charge that you look at this from your technical expertise. We want the recommendation is practical, that's implementable, that can achieve at the end of the day approval of these different proposals. Looking at our federal regulations and consistent with some tribal laws and regulations too. So we met every 2 weeks when these proposals came through. Believe me, we had lots of discussions and protracted dialogue on, is a cutting permit needed for a tree? Because you have a right of way. And so those folks were very vocal. Then we looked at consent on mixed land status in the Eastern specifically. So we went at it and we really, it was like a churning of all the different requirements that we had to go through. We were very successful. We got those proposals out in their very short time frame. So I want to tell you this as an example of success that I think we can replicate for the ARPA proposals for Eastern. So how would that work? Well, because the proposals are initiated from the Navajo Nation, and the nation got the funding for it, I think either DNR and actually more natural resources, I guess, and the community development should be the lead on creating a work group team. And we also mentioned this to former president, that how do we develop an engagement team between the two entities, BIA and Navajo Nation, so that we can look at all the proposals. Again, we had our internal immediate action team that was always working on this side, but we were going to bring those folks to this engagement team. So I think the opportunity is there to have some type of engagement team to do that. And so I highly recommend to RDC to help move that forward. And we'll be there on the calls in person, whatever we need to do from the BIA, because we will help, tribal community members at the end of the day. That's what we want. We want those folks to have broadband. We want those kids to have broadband. We want the elderly to have that. We want the veterans to have it. We're very aware of our community profile of those tribal members that need help. So that would be my recommendation, Delegate Simpson, is that have an ARPA, you could call it immediate action team also. We'll grant you that. But anyway, so we could do that. That's one thing. We'll continue to do education from our side as we're doing. We're working with chapters, we're educating on the rights of way applications, the requirements, all those things must continue. So we'll keep doing that along the way. And again, where there's, like for example, Eastern, we've been meeting with the McKinley County Road Department on a lot of road challenges that are happening within McKinley County. We've been looking at other counties too. And so we'll continue to provide that engagement on it. The regulations do allow in the application process that the line officer, either RD or myself for Eastern, to sign off on 4 categories for consent. So again, it's really drilling down to the details of the application. So for example, those individuals that might have passed, that might have ownership on allotment, those decedents, the superintendent can sign on behalf of that. So again, without getting really into all the details there, but there are ways within the process that we can help streamline or at least identify those ways to get those applications together quickly and move it forward. But I think the main one is getting this work team together if you would like to do that. I want to also base my response on 3 things real quickly, especially coming out of Eastern Navajo Agency. Being there over 10 years, I really have some good experience in working with the different stakeholders and entities. So based on that, I really found 3 models that we use to address a lot of the challenges of Eastern. The first one, again, I mentioned several times, the Manuelito model, that's really looking at a project that's very dependent on allotment. So if you have, one time we had a situation, Manuelito chapter, where we're trying to work on the roads, and the road had a lot of allotments. So we were able to use that model, concerted focus, 2 week at the chapter house getting consent. So there's lots of ways that we can efficiently do that. That's what I call the Manuelito model. Then we have the Herfinal model, where we looked at working with the city of Farmington on using service line agreement as the vehicle to push a lot of these service line drops for utility. We realized in that area, there's a lot of existing infrastructure there already. So the focus was on how do you pull the lines off of that, which already has a right of way. So a service line agreement is something, an agreement between the end user and the utility company. BIA, we don't have to approve that. So that's a model that we looked at for a Herfinal model. And the newest one that I came up with is the Naize, and Honorable Delegate, you're very much familiar with this. The Naize model is what I'm calling, based on Ojo Encino, Counselor, and Herfinal, all the impacts on the land there through traffic and getting the right of way on mixed land status, including BLM, including state. So we have a process for that also, mixed land status. So all these models could be used as to support this immediate action team that I'm talking about, because we have experience from eastern side. So again, we have had only one ARPA proposal that came to eastern, which is for Tojile water line. And thanks to Southern Miller, they've been excellent in helping us at Ojile. So we worked through a very efficient way of getting the right of way approved from Eastern. So now that's on its way. So those funds are being used for using ARPA for Ojile. So yes, BIA, we're supposed to be the expert on mixed land at Eastern, and we are, and we're willing to help, and we're there. Thank you.
So that would call, and that's a really great recommendation for the ARPA immediate action or response team, and getting the key stakeholders pretty much at the table that have ARPA projects, and then also departments that are part of getting either right of way or the consents to be approved. So again, thank you for that recommendation, Mr. Sosi. And I know that this is what NTUA had brought up with the CARES. There was a streamlined or shorter process to have that faster turnaround time to approve a lot of these projects. And it was a high percentage of projects was completed because of it. So again, this would have to almost be the same tactic that the Navajo Nation needs to do, because right now, I know Division of Community Development is here, and I know that Mr. Waseta, you're new to the division. I don't know to this point what you've been experiencing, but once this team does come together and hopes that, I don't know how RDC would have to make a directive to get this team set up so that we could start getting these projects out, like, okay, what are some of the challenges? And we're gonna listen to NTUA, the next item on the agenda. So right now, I'd like to go ahead and yield the floor over to Mr. Castillo in the Nahal Jishnat, and I do apologize. So you do have the floor for your presentation.
Thank you. Sharon Senegisha Rick Steele, Navajo Nation Department of Agriculture, Banashin. Toge cleaning a kite in there, Egan, Navajo Danish, Airstretch, Neighbor System. So I think that's a shadow, and Naga, that's another. A coco, Diquai Gigi, Ya, Hait Aw, Yadi Adolandas, Ito in the Day, Hait Aw, Yadna. Adolagi, ya, you can't do gato in the busy kite or little in the day, Yako, Adolet, not yet, then it's so by yesterday. But before we get to the PowerPoint presentation stuff, I want to kind of emphasize on the Treaty of 1868. We're on a reservation, but Kagi date, it's not like it. Out of Treaty of 1868, given nothing and the Kevin and Honzago is on it. So Article 1 of the Treaty of 1868 basically says, you can get arrested and punished, for doing things that are illegal on the Navajo reservation and stuff. And basically you have to reimburse and or do whatever it is, and you can read it for yourself on the Treaty of 1868, and that basically Article 1 just says, and that's where 25 CFR 167, 166, 161, 700 Part G would all come in as grazing regulations to the land that we are all a part of. Article 2 just basically says, and it was emphasized yesterday, that we have use and occupation. That's obvious. We're here, we're using it, we're using it to the best of our abilities. And we're occupying this. Article 3 just basically says, that we have to establish schools, churches. Our kids have a right to go to school and everything else and stuff, and Article 4 basically says, if there's cases of damage and destruction, on persons or property, and you have to have evidence, and it has to be in writing before you can do any objections to anything. Here we are talking about people that are saying no to something. They don't even have it in writing. We don't even know what their objection is or why they're opposing it, how it adversely affects them and stuff. The Treaty of 1868 basically says, that we have to have evidence and it has to be in writing. And basically Article 5, again to the gentleman here, Mr. Zani here, we are given the opportunity to commence farming. We can farm. We can ask for land. Anybody that is over the age of 18 can go and acquire land for farming and stuff, and that's Article 5 of the Treaty of 1868. And Article 6 basically says we have to get educated. And as long as we're educated, as part of the treaty, you know, we have a right to go to school, college, whatever it is that we need to do and stuff, you know. Article 7, again, emphasizes that a family can select land. And they can basically, if they're in, that they have to be intention and good faith that they can cultivate and use the land for farming. And it might be for grazing. Whatever it is, it's good faith. According to the Treaty of 1868, Article 7. Article 8, you know, it says that the federal government will provide clothing, whatever else, and I always call it tribal clothing because I went to school at a boarding school. And they also gave us the right to make our own clothes, our own blankets, and basically sell it and do whatever we need to do. So those are goods, you know, that we have to do. But here's the emphasis under Title 9 or Article 9, you know, it basically says that any tribal member relinquishes their rights outside of the reservation. As to satellite reservations that are out there that are basically outside, anything that's happening at that line on the outside, we as Navajos cannot even object or do anything to that. But obviously, in some cases, it's going to go right through. And we should have that right to utilize whatever it is that it's in the form of utilities or whatever. But it goes on, it goes and says, number 1, you cannot oppose to railroads. Number 2, will not interfere with construction. Will not interfere with construction. Number 3, will not attack any person at home. Number 4, will not capture women and children. I guess that's what we were doing and we were not civilized or something, okay? Number 6, will not in the future oppose the construction of roads, mail stations, works of utilities. In the Treaty of 1868, number 9. Number 10 is part of this, whoever's operating the PowerPoint. The only reason why I wanted to start with those is because, you know, this is where Article 10 comes in. And it just basically says, you know, that we can basically agree on certain things, and it says, yes.
Real quickly, if you'd like to go ahead and get your lunch, you're more than welcome, and we're going to continue this dialogue. So thank you, Mr. Castillo.
Thank you. So right up in here, it basically says, you know, that 3/4 is all we need for consent or anything. We have dialogue here that says one person is saying no and we can't go anywhere and stuff, you know. In the Treaty of 1868, it says as long as 2/4 of the people are agreeing, then you should do whatever it is that needs to be done. So if you have 4 people that are considered in this one, 3 are saying yes and 1 is saying no, you should be able to proceed according to the Treaty of 1868 and stuff, you know. But it goes on and it basically says you cannot deprive the land user. You have to get their consent. But again, the Treaty of 1868 also says if you are going to do something, then you have to have evidence and you have to have it in writing, not just verbally saying no and going from there and stuff, you know. So basically, so that's the first slide on this one here. And then it's on Article 10 of the Treaty of 1868 and stuff, you know. So again, Article 10 is just providing transportation for the sick and feeble back at the time. And also on Article 12, it basically says, you know, that we are going to leave Bosque Redonde. We're going to come back home. We have the right to obtain sheep, goats, cattle, and we'll be able to do whatever it is to make a permanent home and a permanent settlement on this reservation here, and that's on Article 12 of the Treaty of 1868, and that is where our permits are basically coming in. Number one, to take care of the land, preserve it, and that's our biggest asset right now. As long as we have the forage, the grass and everything out there, then we should be able to raise livestock. But if we don't have that out there, then we don't have any ability to do anything with those trees. So again, so that's the Treaty of 1868. In the highlighted area there, that the Navajo tribe, the Indians, us as Navajos, and they, if we leave the reservation, settle elsewhere. Elsewhere to me is like Gel. Elsewhere is any site out of the reservation and stuff. And we basically forfeit all our rights, privileges, and anything that is related to activities on the Navajo reservation. So we have consents that we are looking for people that are whereabouts unknown. We have no idea where they're at. Their whereabouts is unknown. We're looking for them. They might be in Denver, they might be in Boston, might be in Canada, might be in Japan or something like that, you know, but once they leave the reservation, then they really don't have, they have relinquished their rights and they have forfeited those privileges and stuff. You know, I just wanted to emphasize that based on the Treaty of 1868. Go ahead. So this particular one here, there is it's in a memo form, and I will give it to the resource committee and stuff, you know, and it basically just says, you know, that according to the Navajo Nation, for land withdrawals, you know, an open range grazing requires consent from the valid grazing permittees. And valid grazing permit consent for development and anything as far as the disturbing of forage. You have a grazing permit to utilize the forage that is coming out of the earth. Anything that's below that is something we don't have access to. We're not saying no to anything. So with a grazing permit, it's just basically forage that is out there. Okay, which takes us to surface damage compensation in the 1401, 1402, 1403. And in those areas, it's just basically forage that is out there. If it's not present, if it's not there, then there's nothing to pay. Okay, so anyways, it just goes on and basically says, you know, that the grazing official basically is the person that physically verifies who the land users are in those areas. Not to go out there and get consent from these individuals. Their only job is to identify who the land users are in that area, okay? And we have officials that basically say, oh, man, I'm making my job. I work 24/7, you know, I can go visit whoever and stuff, you know. No, your job is only to identify the land users. And that's basically what this is saying, you know, the grazing official basically completes the field clearance certification. Basically says, these are the number of people that are utilizing that area. Now it is you as an applicant to go out there and get consent. Once they do, there might be some clarifications that need to be made, because the individual that is acknowledging this consent by the permittee, the land user, is the grazing official, the elected official, the land board, and or the grazing official. There is nothing in the laws that basically says a farm board does any acknowledgement to any consents and stuff. Okay, nothing at all as far as farm board. It's really district grazing committee and the land board is the only ones. Farm board members are basically looking at an area that is already supposed to be withdrawn for the purposes of farming. There's not supposed to be any activities. But what do we see driving down Shiprock, Hogback, wherever? A lot of homes that have been developed on there. If we go to mini farms, it's supposed to be farms and stuff. And now there's houses inside there. There's even burials inside those farms and stuff, and that's not the way it's supposed to be and stuff, you know, so. But anyways, it just field clearances that basically the grazing permittee has consented to, and if they are opposing to it, then they're supposed to put it in writing. I have yet to see an opposition to a project that is actually in writing, person saying that I oppose it. I've never seen it. We talk about it all the time. People say no and stuff, you know, where is it in writing? It needs to be in writing. That's the only way that we can basically deal with some of these issues that are related to consent as far as, and it basically says valid grazing permittees. Valid grazing permittees are people that are in compliance. If they have a 10 sheep unit permit and that is what they have, and they have 2 consecutive years of tally and stuff, they're in compliance. Anybody that is opposed, and this is usually 100% of the time, is people that are basically habitual trespassers is what I call them. They have a 50 sheep unit permit, but they are running 200 sheep units out there. They need more land. And we're basically allowing them to do it by not doing anything. There's no interreaction to these habitual trespassers that are out there. Go ahead. So land user consent, you know, before the Navajo Nation BIA can approve a lease, you know, any existing rights held by the affected land user, usually the grazing or land use permittee to the proposed lease site must be diminished. The diminishment can be voluntarily, where the existing land user consents to diminish his land use rights by allowing the lease in this area to happen, land use area. Or it could be an eminent domain, as we were talking about it yesterday. The common problems that arise with these applicants or applications is obtaining users' consent. So it's based on land use permits, grazing permits. That's land use permit itself. Gentleman mentioned here, you know, about land use permit. A land use, does anybody know what number 1 says on the land use permit? They have these in their possession. It's something that they're arguing that they have rights to and stuff. What does number 1 say in that? Basically says, this land is yours to keep as long as beneficial use is made of it, which means you have to farm on it. In our tribal laws, it basically says, if you have a 2-year non-use, 2 years that you didn't cultivate and stuff, it's up for cancellation. I don't know how long we've had these land use permits and stuff. A single one has been canceled for non-use. Yet the lands are out there with rabbits 6 feet tall. 6 feet tall overnight, 2 years or whatever, it has to be at least 10 years or more. But they're out there, people still claim. A land use permit itself, we're talking about probates yesterday. Land use permits should not even be probated. Because that use permit, if you flip it over, it's a will on the backside. And the person that has that permit on there with their name on it, they should be able to basically get the best area on that. But most of the time, 99.9% of the time, they're on the backside. On that, we shouldn't be probating any land use permits whatsoever, because it has a will right in the back of it. Grazing permit basically has a square right in the middle, and it says you have to have management. You have to manage the land. You can't just use and you know. So going on a tangent here and stuff, you know, but customary use area arises in grazing disputes.
Anytime we have disputes and stuff, it's customary use area and or claim use areas. Where an individual standing right here says, that area is mine. Over there is saying this land is mine on my side, over on this side. That person over there is claiming all the way over here, so all our claims are overlapping, but they're not defined. Customary uses basically has a process. It's called an application. All the land users have to consent and say this boundary is be by you and your family. Where the fence is going on this side is going to be mine. And it's basically used to be approved by the resource committee. Resource basically stepped away from that, and now the process goes from the district grazing committee straight to the Bureau of Indian Affairs. And those are the times that we have customary use areas that are defined, but it is courts basically says that it's a property interest. It's not a deed to the land. The permit is not a deed to the land. They're in the form of a corral, livestock, and or anything associated with those might be property. But the land itself is not part of that grazing permit. It's not a deed to the land. It doesn't, there's some use that you have a of utilizing that land, grazing on it. And we're not supposed to be hauling hay every week to our livestock. But that's what people are doing. We know there's no feed out there. And here they are basically just hauling on a weekly basis and stuff, you know. We know the land can't sustain anything, but yet when issues come, they say it's my land. Get off of there, move out of there, get out of here. You know, whatever it is, you know, people are basically saying those to each others and stuff, you know. So a grazing permit alone does not give the owner the right to use the land. Doesn't give the right to use the land and stuff, you know. It's for your family. Basically for livestock that could be out there. Go ahead. So customary use areas, again, basically it's just a concept that is out there. And the Navajo Nation court has already determined a lot of different cases and stuff, you know, that the Navajo tradition, basically land tenure is a principle and one must use it or lose it. Case laws basically say that. You have to use it. And if you're not using it, then you're going to lose it. You're going to relinquish it. It's going to be canceled. For those permits that are just sitting idle, people have passed away 30 years ago, 40 years ago, but the permit is still there, hasn't been probated and stuff, they should be canceled. You either use it or you lose it. And that's the court's interpretation of these permits, whether it be an agricultural permit or a grazing permit. Go ahead. Customary trusts, claim use areas. Basically within the common law, you know, the primary means of processing land for a family. Again, it's a family deal. I can guarantee that there's probably maybe one family out on the reservation. We're almost 500,000 strong and stuff that might be working in unity together and stuff. But the majority of families don't see eye to eye on a lot of different things. Brothers and sisters, their kids, some of them don't even know each other. A lot of people don't even visit each other and stuff, you know. It's all because of land issues. The land itself out there, but it's basically for family. The customary trusts, you know, And it's supposed to be held for the benefit of the family. The customary trust is a unique Navajo concept that requires the appointment of a trustee. We do have some trustee permits out there that basically has multiple names on a grazing permit, and they would have exclusive rights to those. And as time went on and stuff, they basically are denying each others the right to utilize that permit, although it has their name on it and stuff, so. But basically, number one, the animal units in this grazing permit must be sufficiently large enough for economic viability. The smaller the permit, the less economical benefits a person has. Back in the days when these permits were issued to the heads of household, which was maybe in the 1940s when the first permit came out, a lot of these permits were big. 350 is the highest one can have. But prior to receiving a 350 sheep unit permit, they were probably running 2,000 head of sheep. But the government reduced it. Livestock reduction. At that point, they received that. Others received certain amounts of sheep units and stuff, based on the area that they were in. Number two, land must be put to its most economical use, or should be large enough for land must be put to its most economical use. Lost my chain of thought there. Number two, the land has to be economically used, beneficial use also. Number three, the most logical heir should receive land use permits, grazing permits. We should not even be probating the grazing permits. If we look at the model for MPL, knock on wood, those permits were canceled by the United States government. Ninth Circuit Court out of Phoenix. They're the ones that canceled that federal permit. Once that person is deceased and stuff, we cannot cancel and probate a canceled permit. So under NIRA, the Navajo Rangeland Improvement Act, we had in there heirship, which RDC approves. And that's what we're using on MPL right now. The permits have been modified. It's still a federal permit, but it's been modified, taken back to the Department of Interior and spread out throughout the world for people to comment. We didn't even receive one comment from anybody. On that, it basically says you have to have a beneficiary. On these grazing permits for MPL, you have to have a beneficiary. Hidnage do ahuzan. Ebony na equagi I don't hashing a bishop cado. Quagi don't have just spaogo. I don't bother. So we're not probating any grazing permits on MPL. And we call it heirship. Okay. Number three, the most logical heir should receive. I already went through that. Number four, use rights must not be fragmented. Grazing permits and they that on Chicago so that is so. So go on the quaggy one be a heart, honey quaggy is so go. Other grazing permit is so go to then there's the change, then there's the yane could neither. And then the other does quaggy is a top of that go quaggy Santa Quille. That's where all our disagreement and disputes and everything arises from there, from these fragmented grazing permits. Under NIRA, they basically were saying, we know of these permits and where they and how they were fragmented and stuff. Let's put them back together. Aji Jackie Hashida Hasna Aniki Kayaki Kajus. But that didn't happen. That was NIRA. Resource Committee asked for that presentation. We did it. And we have not heard anything again as far as NIRA, the Navajo Rangeland Improvement Act. So again, you know, it's basically has to be beneficial use and those are some of the case laws that basically state these and they're as they're awarding this permit to an individual, that it has to be of beneficial use. It has to be large enough to where they can make a living off of it, the grazing permit. Go ahead. NTUA. Basically, number one, the customer submits a project request to NTUA. That could be whatever the chapter, whatever it might be, but there is a chapter resolution that is required in order for these district offices to consider what is feasible. The primary surveys, designs, rights of ways, packages, whatever it is, that's all done by NTUA. Maybe there are some site privileges, you know, that might be granted by Resource Committee for not paying any right-of-way fees or compensations or whatever, you know, but that's between the NTUA and the Resource Committee. Right-of-way process begins at the headquarters, you know, there's archaeological surveys, biological surveys, consent requests, and that's what we're here today for, is consent. And basically compiling all required documents, submit to the Navajo Land Department, GLAD, whoever that might be, and their approvals are received, permits, and then whatever it is for encroaching on these areas. Go ahead. So there was a letter that actually went out. And basically it was to the right-of-way agents and stuff, you know, and the right-of-way agents by NTUA basically said, we are confident enough to do our own right-of-way consent. We're gonna do it. They're employees. They're employed by NTUA. They're right-of-way agents that are out there. And in this letter here written by Mr. Mike Alona back when, basically said, NTUA basically said, we have the confidence to do it ourselves. Every other week, NTUA right-of-way agents come in and they're having problems getting whatever it is. And then we try to assist in whatever ways that we can to move the projects forward and stuff. But they are basically the people that are employed to visit with the people right there on the ground that live there, that utilize the land, and basically would provide their consent to whatever project it is, you know, and they basically said they had the confidence to do it under their employment with NTUA to obtain consent. Go ahead. And these are the field clearances checklists and stuff. The grazing official's only responsibility, again, is to identify the number of land users that are in that area. We used a half a mile as one source. I'm going to use the Gallup Waterline project as an example as far as consent and just based on compensation. Along that route from Shiprock all the way up to Gallup and stuff. There are some grazing officials that basically have relatives that they said needed to be a part of that compensation. They live about 15 miles away from that project. And they still got paid. Now what you know is who you know, and how you're gonna manipulate your authority, whatever that might be, but it should be within a half a mile. And it shouldn't have been compensated to begin with because it's in the ground. They're gonna basically reseed and do everything to reclaim that area, and it's probably gonna be the best green grass that might be in there for a while until they chew it all up and pull the grass out by the roots and everything, and there'll be nothing but weeds in there again. But nobody should have been paid. Nobody. Because for the sake of compensation and stuff, what we've always emphasized from the Department of Agriculture is any compensation that is done to a land user by way of a permit, that permit needs to be adjusted their sheep units decreased. Again, I do not even know of one grazing permit anywhere that has been adjusted to reflect payments, land that has been taken away, and animals are not even grazing in there. But they have the same permit with the same sheep units, and now they're encroaching on other people that are users of that land when they have relinquished and basically gave up some of the lands that they have. And based on size and stuff, you know, and that could be evident in Fort Defiance here in Window Rock, Palm Point, Chinley, wherever that might be. The consent basically is the land user, and then we basically have the acknowledgement by the elected official. So on this one here, basically the grazing official, elected land board would do that. There's signature there that basically says, I verify that these are the land users that are going to be adversely affected by this permit. Adversely affected. Go ahead. So again, Article 10. We cannot just take, we have to use consent. Do whatever it is that we can to contact these people and provide or get their consent. Right-of-way authority, surface damage compensation, only one person within the land department. This is coming from the elected officials, the grazing officials themselves. When we are talking about consents and or right-of-way authorities. And at the time they were saying Navajo Land Department is really glad. I think a gentleman is sitting right here, Mr. Howard Martin, that might be the only person that basically has any knowledge to how compensation values of those could be done. Aside from land appraisers from the Bureau of Indian Affairs. Disputes, who or which department will be handling disputing parties? The land department, GLAD, whoever approves the project. They're saying we're going to move on, we're going to do it. We still have the issues of disputes. Who is it that now is going to handle this? Is it NTUA? Is it land department? Is it GLAD? Is it Department of Agriculture? Is it the grazing official? Is it the land board? Who is it that is going to actually deal with this? We know Office of Hearings and Appeals basically is given the authority based on disputes to appeal somebody that's appealing and or hearing towards this. We know Office of Hearings and Appeals is there as administrative law judges. But who is it that actually would be the detail with doing something that the land user is basically said no to, but it proceeds and stuff. There is no mention of intimate domain compensation or adverse disposition of land by council delegates, Navajo Land Department, whatever else. We talk about it a lot. We emphasize it and stuff, you know, but there's no process that I have seen. Maybe there's one that's going to be developed from this work session here that will begin to establish how an intimate domain can be done. Leden has tweeted on Nilago Bahuni as chapter officials, Nita Ad. What say what that's a cargo or intimate domain is to this or to be what the Nisa Aji. To Naznatige Soto, I don't let us Yegos, Ninigi and Gadget Ingo go ya, Bekasato, Nisa Aji, intimate domain. Oh, yeah, that's true. Other a cocoa bad which she's got on. Question: if the right of way land base is withdrawn from a certain purpose for a certain purpose, it is no longer a grazing area. Therefore, are these grazing areas going to be fenced in? Answer should be yes, which includes home site leases. The home site lease bata na dosa ta hanno kadeng ho beka shi the bethi ko de ado that's like kita na nego go when the regulation says you may fence in your home site. They should be fenced in. so the livestock can stay on the outside of that fence. And if an animal goes into where land is withdrawn, whether it be a chapter compound, animal goes in there, there's no grazing allowed, and that they should be picked up right there and then. They're not allowed to be in there, as well as the right of ways. Along 264 in the Indian route that is out there that has a fence in it, animals venture in there, they should be picked up. The grazing official, the land board, the Niki agent, adjustments to grazing permits will be needed. And if the remaining land does not support 10 sheep units, will the grazing permit be canceled? Because you can't have a grazing permit for less than 10 sheep units. If they already had a grazing permit for X number, let's just say 15, there's a certain amount of land that is withdrawn from that area, whether it be for a community cemetery or whatever that might be, that causes the grazing permit now to be 9 sheep units, should be canceled. And or adjustments made and stuff. Go ahead. Land user consent, again, the customary use area, the customary use rights and stuff. The land user consent, both Navajo Nation and BIA, they can approve a lease, whatever it is, land withdrawal, utilities, etc. Any existing rights that are held by the land user permittee to be diminished and stuff, that basically is a voluntary thing. The user consents, to land use rights and stuff, can be diminished involuntarily also, and that's where eminent domain comes in again. Okay, so any objection to any project, again, there should be some kind of evidence from this individual that is basically saying no, and it must be in writing in order for anybody to consider if that is legitimate or not. If they just say no, then project should just move on. Just move on. The burden of proof is on them as to how adversely they will be affected and stuff. Good. I think we're almost there. We're at the end. So and I have some other documents to give to RDC. And that's based on discussions, on these PowerPoint that will clarify the contents of those and stuff. Treaty of 1868 is one. The Grazing Official Workshop is another one. The property rights that is done for the Department of Agriculture is another one. So I will give those to you. If not, I will email it. Thank you.
Mr. Castillo, for your presentation and also sharing some of the information through the right-of-way authority process that grazing officials boss of Lahagi. It's very ironic to learn and understand now that a farm board representative really does not have that authority. I did not know. So it's, and that causes for really looking at the current regulations or even the process or the language provision under Title 16 that needs to be revised, because who goes now to the farm board location to exercise filling out that field clearance checklist in case there's a project that's coming up for infrastructure development. So there's a lot of hit and miss. I'm really glad that we're having this dialogue again. Thank you, Mr. Castillo, for your presentation. And it appears that ARPA team to be coming together really well benefit from these projects. So again, it's just pretty much what we've been covering the past couple of days. So right now, we have 5x7 index cards on the table by the sign-in sheet. If you have questions, and it was going rapidly yesterday, so just pose write your question on it and your name maybe at the bottom so that we can go ahead and just read out the question, and we'll go ahead and get it responded by one of the departments that are here. So now I'd like to go ahead and continue on with item letter G on the agenda. presentation on issues related to obtaining land use consents for TAA relating to Navajo Nation woolly owned entities. Presenter would be NTUA. Now here we want to understand, because NTUA is vested with a lot of the bigger right-of-way projects. We want to understand what is working and what is not working. You've heard the dialogue for 2 days now that it's supposed to be like this. Is it really like that? We don't know. So with that, Ashonda, go ahead and share with each other. I don't know if you have a PowerPoint presentation. I don't know who's making the presentation. Mr. Coombs, okay. So we'll go ahead and yield the floor over to you, Shanatani.
Thank you, Madam Chair and members of RDC and everyone here. It's been a great dialogue. One of the best I've heard. The right experts in the room, they've given a lot of very useful, meaningful information. And, you know, Mr. Zani said, everybody needs to be educated at the local level. Here at the top level, we also, I think everybody here probably learned something new. So with respect to grazing permits, there's a number of issues. I'm going to go through the list, but I think some of them have been somewhat covered and resolved today. But just so that we can all get an understanding, just what we experience in executing these things, going through the process. We had one of our right-of-way agents receive 4 permitting names from a grazing official for a line extension that was approximately 1,500 feet. So within 1,500 feet, they gave us 4 names that we had to get signatures from of grazing permittee holders. So the question is, do all those people have some grazing going on there, and why is there 4 of them? So those are the kind of things that we come across. Non-responsiveness from grazing officials during the consent process. Some are very active, very helpful. Others, we have trouble tracking them down. They're not returning the calls, texts. We even try to find out where they live, go to their house, knock on the door. So we have people on the ground that are physically going out there trying to not just locate grazing permittee holders, but the grazing officer as well. So, you know, we need to find some way of helping them understand they need to be somewhat available to us. Grazing officials providing a name list for a project, but the names provided list permit holders that are more than 1/2 mile from the project site. So what we have been told is that we need to contact those people that are within 1/2 mile, because those are the impacted people. But we basically get everybody that's in that region. And we end up talking with a lot of people that may not actually be impacted by the project. Grazing officials have provided names for invalid permit holders. And right-of-way agents discover this when they meet with the individual, and the individual themselves disclose they don't have a permit. So maybe the records are not clear or not updated. And we know oftentimes those records, when we get it, the contact number is wrong. It's not the right number, and there's just not an updated version. Supporting resolutions for chapter projects are more difficult to obtain, with more chapter officials and administrations asking for compensation, not necessarily the permit holders. So that's where we run into problems with the chapters, is the chapters want something out of it. They want to receive something. Mr. Zani talked about a project that is in one chapter's area. It serves another chapter, Coal Mine Canyon. When you drop off from Tuba City down into the valley of Curly Valley, the line is right along the ridge line. So once you drop down, the wastewater plant is down in the valley. And that plant was originally built by Indian Health Service way back in time. It's like 60 years old. So it needs to be replaced with a treatment plant. It's also been dialogued by current environmental requested. Existing area is in the flood zone, so we had to move it upstream and outside the flood zone. The permittee holders are farmland holders. 2 of them have not had any claim on the property for 2 years, so they're telling us those are invalid. There's no permit holder. There's a small portion of another farmland, about 10%. The consentee signed off on that one. Okay, but we're still getting protests from the other farmers, even though we're not impacting their farm. They've made demands like, I need a new house. If you give us a new house, we'll sign off on it. One wanted housing for everybody in Curly Valley. These are the types of things. Members of the chapter said, well, we want taxation from businesses that come out into the city to come to us. And it's really a regional project. It serves everybody there. Cameron goes there, Coal Mine Canyon is served by Tuba City, Tonalea. The majority of people work there, they get healthcare there, they send their kids to school, they get groceries, they get gasoline, all those services are in Tuba City, so that Tuba City is kind of the hub there, other than going all the way to Flagstaff. So we're trying to promote it to them that this is a regional benefit to the whole area. And the plant needs to grow. The Club C for Tuba City has a bunch of projects they want to do. Economic development has a bunch of projects they want to do. Indian Health Service has some more extensions they want to do to serve more people, but we need to upgrade that plant. When Western Navajo water rights are settled, there's going to be a huge amount of water coming through there. We have to upgrade that plant as well for that reason. But right now, we're almost at the point of having a moratorium, but no more connections. So those are the kind of things, and I'm glad to hear from Mr. Alona and others that they gave us a pathway. We've made multiple contacts. The vote was actually very, very close. It was like 48% to 52% and voted down. So, you know, if we can move that project forward, bring it to the committee, that would be great. But those are the issues that they run across. You know, we have grazing permittees that refuse to give consent for one line because they don't like the neighbor. You heard those before. I think those are basically most of the things we have that we run into. A lot of it is maybe not so much the process, but the people that are supposed to administer the process are not executing their responsibility in a timely fashion. So somehow that has to be resolved. Okay. The one thing that I would like to add on top of all that real quickly is what we're not really hearing too much, and I think we would recommend that you have another work session like this with HPD, Historic Preservation Department, because they have a lengthy process as well. And also with Fish and Wildlife. We have to get art clearance and bio clearance. Okay. And I really like the summation outline that you did at the beginning to start the meeting, starting point, build off of that. There was a couple of things that I think might not necessarily be correct. The comment was made, Intuit requires a home site lease. Intuit doesn't require the home site lease. We're required to provide a home site lease as evidence before we can get right away. And there was also a comment that EPA requires the septic system to be within the home site lease. It's actually the home site lease requirements. When we met with EPA, we said, is there a reason why you want it inside the home site? They said, no, it's inside the home site requirements. There's not a reason for us to have it inside the home site. So there have been solutions offered. When we clear for a home, we go from the center of the home and we clear a 300-foot radius for archaeology and biology. We have to go through HPD and Fish and Game to get those clearances. Okay, so we're cleared way outside the home site boundaries because we know we had to maneuver equipment and move around. So it is cleared outside the home site. It's one statement that was added in the home site requirements. And if that one statement was stricken, that would solve the problem. Okay, that would be an easy fix. We've also run across, you know, people that don't have home site leases that were stuck, their projects on pending. When we get that 300-foot radius for Arc and Bio, is something we want to talk with Land Department on, is would that Arc and Bio be sufficient while we're out there surveying the water line to the house? that we have them pick 4 corners and we do the home site lease survey as part of the project. I've already gotten consultants that have quoted me costs, and it's about $600 to $742 per home. So for all eligible customers, we could do the legal survey around those homes if they're on the project, because we're already getting the ARC and the bio. And if we get those are the things that hold the people back, because they can't afford to get the ARC clearance, they can't afford to get the bio clearance, and they can't afford the legal survey. And so if we cross that bridge for them as a part of the project, we can get all the documents necessary for them to get their home site lease. Then it's a matter of just that package is up and go back through land department. So that's something that we're offering as a solution. But and there's a number of things here that I went through, but I heard a lot of progress today. I think there is great hope for me today. And I've seen these types of dialogues before. My only recommendation is that we get this documented so that we go forward. Okay? The EPA director, the only thing he has on record is what's in that home site thing. And when I ask for a construction permit, I can't get it because he's only following the law. It's not his fault. Okay? The other thing that I didn't see here addressed was, I believe each one of these reviewing bodies need more staff. They need more reviewers. And when we're trying to get biological from Fish and Game, it's always the same one person. And those people are trying to review everything that's coming through for Navajo. Same way with archaeology. We're dealing with one person. They're trying to clear archaeology for everybody. So their process may have been streamlined to go quicker, but there's only one person, so they have a number of things stacked up that they got to go through and wade through. Take that stack and tip it over and put more people on it. You can get through those clearances quicker. So that would make this whole thing work if we had the ARC and bio go through the same type of a dialogue. And I think that would really help us. Thank you. We'll stand for any questions.
Yeah, Mr. Coombs for sharing that information with us. So here, I think it's just a lot of accurate information sharing. Mr. Holona, since you oversee Division of Natural Resources, the recommendation that was made, and I think this really goes out to Department of Ag, Mr. Castillo. So I know that you work with the grazing officials under Department of Ag. And one of the things that is being addressed here as a concern when they're trying to get right of way from NTUA through the TAA is the grazing permit names that are submitted by the grazing officials on that field clearance checklist, right? Some of these, so I would assume that the grazing officials would know who has, okay, so when we said valid, you explained yesterday, Mr. Holona, that they have to have the past 2 years of a physical tally done, yeah. Auto in that just within a half-a-mile radius, okay? Somewhere there is a communication gap with the grazing officials, land board, and even farm board right now. That they're not conveying this accurate message to the grazing permit holders. But again, also, maybe one of the other barrier is the conflict of interest issue where they just want to put their family's name on there in hopes that they get compensated. Although it was mentioned like they're off 1.5 miles than the proposed half-a-mile radius. So I just think that the grazing officials going forward need to be re-educated. And as a division director to Department of Ag, I really think that's something that needs to be, they need retrained on, or how the approach or the methodology that's going to be taken. That's something that needs some immediate attention. And it's just not going to be for the ARPA projects, but going forward. I'm glad that he did mention that is HPD and Fish and Wildlife. I know that they're a big variable to this equation of approving a right of way. And again, that would be an area that, I guess we need to, I want to kind of step away from doing work sessions because, and it's good at the same time, but RDC is just so busy. And then I also have to really take into consideration my colleagues. They have to commit their time to the chapters that they represent within their district as well. But maybe going forward, you might want to get together with your team and collectively with General Land Development Department, with Navajo Nation Land Department, HPD, Fish and Wildlife to try to come up with a collective dialogue and maybe invite NTUA, because again, NTUA is the bigger, subrecipient to this ARPA project's monies that was given to us. And again, we are pressed against a deadline. Okoko, one of the things that I'm glad that he, wanted to make clear is that NTUA doesn't require the home site lease, but is it per the home site leasing regulations that you all abide by to have that home site lease would be my number one question. And then the next one is EPA. Yesterday, I know that this was mentioned by Mr. Ashley, now by Mr. Kuntz, is that you have the four corners of a home site lease. The leach field has to go outside the home site lease, but EPA, Navajo Nation EPA is only abiding by the home site leasing regs. Is there any way, Mr. Halona, that it can be put in writing that as long as, I don't know how we can address this, or Ms. Khan, from legal perspective or DOJ, how this can be addressed, because I believe that's where some of the holdup is to get that construction permit from EPA. If it's going to go outside the boundary of their legal description survey plot, okay? So I get thought that's another barrier, it appears. So with that, that first question I posed, Mr. Coots, I'll go ahead and give it back to you for a response, and I'll go ahead and give it to Superintendent Mr. Sosi.
The question again?
So you had mentioned earlier that NTUA doesn't require a home site lease, but I believe that in regards to having that document in hand, is that what you need per the home site lease regulations to have individuals get water and wastewater and electricity?
Okay, so to try to clarify that, when we're extending a line to a home, land department requires that we show that the person being served has right of occupancy. So I can't get righted with the line to the home without us showing proof that the landowner is authorized to be there. So it's within the right of way land department's regulations.
And I think that we have a solution to that, and that's what Mr. Halona had brought up. So that we'll be dropping the legislation for that one, okay? But we just need to address the EPA. But at this time, Superintendent Sosi, I go ahead and yield the floor over to you.
Again, thank you very much from the Bureau of Indian Affairs to provide some of the information here at the session. A couple points I want to make is when we're talking about biological or historical type of issues or problems or challenges, just keep in mind that that's under Public Law 93-638 contract. If there are issues with the services through that contract, we have our staff that is assigned to address those through a very formal process. The AOTR will be the individual that we would have to work with, the awarding officials, technical representative. So, while we're just talking in general right now about maybe some issues or some things like that, but keep that in mind, it's a very formal process that we have to work through if there's a situation, a setback or something like that. The other comment I want to provide is this, and This is in general for utility companies that we're experiencing. These proposals out there are, they're certainly going through the different processes. But from our side, we keep emphasizing to the utility companies, understand the requirements of the regulations. Some of these utility companies, they should be using the service line agreement, the SLA, to address service drops. Again, back to Honorable Simpson, your question about why maybe some of the tribe members are not getting the quick services that they should be getting, right? And I'm aware of some situations in NTUA, with all due respect, you guys have been looking at these different requests for service line. And I told you guys directly that you use a service line agreement, which is just the service. You don't need BIA's permission. You don't need these other requirements, because the understanding is that main line already has art clearance, already has, you know, cultural assessment clearance already been done. So now all it needs is this small service line drop. If it's within the same land status. If it goes another land status, then yes, we need it right away. So please, and to you, I'm appealing to you again, work with our team if there's clarification that needs to be made, and let's get those service line drops happening. What we need at the end of the day is just the document so we can record it. It's really a streamlined approach, and that's what I think the committee is looking at. Efficient, streamlined approaches to helping the tribal members out there. Thank you.
Thank you, Superintendent Solsi, for that.
Mr. Sosi. And Shanat, do you have a response? Okay, I'll go ahead and yield the floor back over to you.
We do use line agreements, and what we've been authorized to do is for water lines, a service line agreement for a water line up to 1,500 feet, and for power lines up to a mile. It's a question, I guess, that I have personally is, why is the water line limited to 1,500 feet, but we can go a mile for power line? And if we had the same mile limitation, we could use the service line agreement much more extensively for all these projects.
Question. So with that, Mr. Sosi. Response to Mr. Coots.
Yeah, I am also curious where that number comes from. I think people are blaming NTUA on it, but I don't know if that's the case, but in the regulations, basically there's two requirements. It's got to be within the same land status for a service line job. And it's got to serve one home. That's it. From the federal side, again, efficient, very clear on that for a service line agreement, service line drop. Okay, thank you.
Yeah. So, Mr. Alona.
The magic number we're bringing up 1,500 was because we only had a tape that went as far as 1,500 feet. So we're limited. I think there's a couple of things that I've narrowed it down to, because I can't find anywhere that have to. I think it was just out of, number one was, if you remember, a Fish and Wildlife had issued a cover bio or service line. And that's where that footage was in there. Is that up to 1,500 feet, you're clear. As far as you don't need a, and the other stipulation was where there is Mesa Verde cactus. If it's in that habitat area, you need to consult with them. And the memo was signed by Jeff Cole. You might probably find in your old file, there's Xerox so many times you could barely read it. But that was the cover that was put on for service line agreements to expedite quicker. But now we're coming back to the full-fledged biological. And we've had many meetings, not only with historic preservation as Chairwoman Jesus is asking about. We've been having some of those meetings. And we're saying that, what if we have a matrix set up to where what we consider to be areas already disturbed. Highways are disturbed, utility lines, water lines, all those things that are disturbed. You know, they all had buffers done around them. And the impacts that result from all of those improvements, that we should have at least, at one time, it was a 1/4 mile from those impacts. And we almost got through with that. Now we're at 1/4, I mean, an 1/8 of a mile. So if we could agree that if you're within an 1/8 of a mile of anything disturbed lands already, that could speed up home sites. That could speed up every project if they're all within an 1/8 of a mile of existing infrastructure. So somebody says, I want a home site real fast. It's like, you get within the 1/8 of a mile, well, that can be processed quickly because we all agree to it. That would help NTUA by trying to get power out to it 3 miles later, at a later date, trying to serve them. So that's something that we've mentioned, and some are comfortable, some are uncomfortable. We haven't come to that agreement yet as to that would be something that could be entertained to speed up all the processes that we're talking about. So that's where that 1,500 foot came from. But as far as service lines, you know, as Superintendent Sosi mentioned, there's no footage requirements. You know, but if you're gonna run a service line 3 miles, you might as well just do TAA, because you know there's gonna be people dropping off after that. Okay, so that's something to consider as well, is that every time you run that line, you'll have new customers pop in, and then you just do service lines, or else we'll be doing them one at a time like that. So those are my response. Thank you.
Thank you, Mr. Halona. And now, Mr. Kuntz, do you want to do a response? Go ahead, sir.
So when I first started all this, trying to serve people, my hair was black. So I have a little bit of history, and I think Lester does too. The 1,500 feet, my recollection, the first service line agreements, Indian Health Service started using them to do their 121 projects. And at that point, I was still working for IHS. And their limitation of 1,500 feet had to do with their financial capability in trying to do economic feasibility. So that's what they limited to. And when the nation started using service line agreements, I think they just adopted that number. And there wasn't really a restriction. But yeah, if you look at 169, it talks about a certain size limitation. You can run a service line agreement. And then there wasn't a distance, a single service. Now, if I run a line to a home and we add another home to that same line, at that point, now I got to go get right away back for that whole line, because now it's serving 2 people. So, but if it's within that distance, it can be done as a TAA, which is also a quicker process. So there's been migrations and evolution that are making these things work much better. But at some point, we still may have to turn a service line agreement into a TAA after the fact. But as long as we keep track of those things, it shouldn't be a problem.
Thank you, Mr. Kuntz. And I do believe there was a question that was submitted, and I will go ahead and read it. We, the grazing officials, have been requesting, asking No enforcement, that is a problem. Where's the compliance officer for land department? So this is in regards to the right of way. So Mr. Halona, since it is directed to land department, we will have you respond, sir.
To be honest, thank you, Madam Chair, OTEM Resource Committee. The need for enforcement has not been ignored. And we've been looking at creative ways. How do we get enforcement people out there? We've relied on internal with the tribal rangers, fish and wildlife, forest, park and recreation rangers. But they have their hands full on all the other matters. So in 2016, Resource Development put the requirements for compliance officers in the regulations. And that there would be compliance officers to enforce home site lease regulations and other leases on Navajo. And it's always been foreseen to have at least one compliance officer at each agency to be able just to focus on those. You see somebody trenching, they could stop and pull over and say, who are you working for? Do you have your lease? Do you have right of way? Do you have a TAA? Same thing with home sites. Who do they go to address, to mediate issues before they get out of hand, and so forth. So since 2016, every year, we were doing unmet need budgets. And we explained to the district grazing committee, Navajo reservation wide, that's what we're working on. As you heard, they need enforcement because they are put in that situation out there. I understand that. And everybody's expecting that they're the ones that are supposed to do something. And so, and then things have changed since then. The disputing families and individuals are more aggressive now than ever before, even towards each other. So then we start looking, maybe it's not compliance officers we need, it might be full-fledged enforcement officers that can go knock on the door and find out what is going on and take some form of action that's needed. Since then to now, we've never been budgeted. Those compliance officers have not been budgeted. I think this is the first year that land department did not put an unmet needs in for compliance officers. Previously, we almost got it up to B&F, and it was between us and the Rangers said, we'll do the work, give us the money. They got additional funds. So those are some of the things that we will be looking at within the Division of Natural Resources to change the enforcement functions and get a handle on the needs, not only for agricultural, but for wildlife and all the other areas. We just need to give them some clear direction and expectations for enforcement on Navajo Nation for the people. And with that, thank you.
Yeah, Mr. Alona. At this time, I'd like to give some time to Speaker Aroso.
I'm glad that discussion is here and you have multiple entities that are here. And it is we have policies that's in place. And whether it's a right of way, whether it's a home site, you have Indian Health Service doing this. You have Indian Health Service working with the Bureau of Indian Affairs saying, oh, you need this, you need that. And so, and then you have NTUA saying, oh, you need this and you need that again. I used to be a right-of-way person, worked as a construction inspector, and I processed right-of-ways for Indian allotment lands, BLM lands, tribal trust lands, and onsen. Ako jo kuja you have the policy that's in place. And then you have another entity over here trying to dictate what that policy is. Oh, no, we think it says this. As an example, anything pertaining to farming. Dag epenal sosas angi. Ere de benal sosas angi. Heish bodni. NTA, Indian Health Service, or is it the permittee? If the permittee says yes, and you have NTA or I say, no, we can't serve you, can't add you onto the project. I've seen that. And I have a person that's beginning the home site lease process. And it's not complicated. ARC surveys have been done. That person has submitted her home site lease in Chiba City. And I'm just gonna see how land department addresses that. And I'm gonna see how NTUA addresses that. You have facilities that have been installed by the 121 program, which consists of archaeological clearances. There's an NTUA service pole there. And there's a call that was made to NTUA, oh, you need a home site. You need this, you need that. Sat there and I was like, is this how NTUA talks to you? It's one of my constituents. And I said, you shouldn't be jumping through hoops. There's clearances already in place. The issue, yes, home site, an approved lease. But kaya I gave it not state. At iji tahadlone it she da di but not state. Hada she alcohol. I really hope that my recommendation is that NTUA, Indian Health Services, the Navajo Nation, whether it's under GLAD and the home site division, all come together to iron that issue out. As an example, NTUA says our right-of-way service line agreements are 1,200 feet. And you look at Indian Health Services over here, Indian Health Services 1,500 feet. And that same question I always ask, what is the policy? What's the maximum distance on service line agreements? You have one Navajo Nation entity saying this. You have a federal entity that works indirectly with the Navajo government having a different number. The entity that has 1,200 feet is a stepchild of the nation. So somebody internally has told the nation, and the nation has told NTUA, told them that's 1,200 feet. And then you have our trustee, the Bureau of Indian Affairs and Indian Health Service working hand to hand, side by side, saying it's 1,500 feet, and that's what, from what I remember from 1996, it's been 1,500 feet with Indian Health Services. And the issue is the communication issue. And somewhere need to come up with a manual. We have policy in place. This is the service line agreement manual. This is what you're going to abide. You have NTUA saying, okay, we'll agree to it. But somewhere you have to align. And that alignment has to happen. And I'm going to follow this, one of my constituents' home site lease process. And it involves NTUA. You got, like I said, they have art clearances already. the botanist survey, whatever clearances through Fish and Wildlife has been done by a federal agency. And the art clearances. So you shouldn't have an issue with archaeological survey. The issue would be a home site, but someone brought service there on that home. That home at that time did not have a home site lease. And I just first work with NTA, document everything, document it, because what they say in the field and what is said in Window Rock is different. And that's the reason why I came to speak a little about the service line agreement issue. I agree with Mr. Holona that an area is not stable. And I always thought maybe we should give that person a grader and work for INDOT. The other is that we really need to look at, sort through the spaghetti noodles. And what I'm referring to is the authority of the grazing officer. Tally counts. Not the back because he not cut. Upon the Kojepe has only be non nishta, but not neat. Non nishiki ya. Ishan odziniki. It's not to say that he or she is the approver of that lease. He or she is this indicating they could la hanzola keya. They couldn't kaya trios. They couldn't eat batina. They stop batina. They stop batina. There's only be couldn't eat of Bebanan are not so spatch so Bebanan are not so native so do it taki rata. Kashi Baha Zohiki Epipansala. Not so stahio societa pomat ete. The data at the che that ate a ga for hesh che lahantishnet qua inle. That thorough training needs to happen. And Naniki a be hosta yitsa shanash the nada yitna. I see how grazing officials can keep that document away from that applicant. I've seen it. Ako what ego has even now has has ani ginad ego has ani hadid other robert ya ego ishan anadia a thorough training pertaining to what is their due responsibility. And if you take the application from a person, if Rowena was applying a home site lease and I was a grazing officer, she said, sign here. They didn't injure cotton, and I did all the due diligence, got the UTM reading and so forth. I put it on, later. It's not my responsibility to take her application. It's the homeowner to hold that application. So Rowena would say, I'm not source with the dish. Hard lana hazo kon. The hard la the GPS had dish the dish look Ado kwa issue numbers on it, ye kwa that issue. Kwa tu kwa la, ye kun the never is kala. Did, a trios. Maybe I'm wrong. Maybe I'm wrong. Maybe that's not the process. But I think that's what the process is. Even pertaining to right of way. If Mr. Coote sends the right of way agent to a person for a service line agreement or right of way consent, the technician will go out to the place and with the grazing officer, here's beginning of line and end of line, whether it's a power line extension, whether it's a water line extension, there's end of line. The beige be ahas so the beige ibana ibna so so that I hope I'm explaining this correctly. The Bureau of Indian Affairs. Not the Shlini. She could have to this king. Kashik ash that initial and later go. You get that each king. Every individual is on their own silos. Go get Eda. No, we do it this way. In the law, it doesn't say how many consentees can consent to a home site. In the law, it says as long as the permittees are in compliance. If there's 5 permittees, in my view, if there's 5 permittees and there's only 1 person in compliance, you go to that 1 person who is in compliance because behezani bika. I hear, oh, you need 2, you need 3. Katane is but I is and not the Shin a Khalid a de travel program. Ni dated ni kago. Eat ego about the wheeling, laid the representation. With that, how is that assurance with the communication from the Department of Agriculture? A dashin so ben and I is in a Ishan or Ziniki. Ash, is there trainings that happen pertaining to that? Because later and our constituents out there are jumping through hoops. Khalid Ajinant Nishash did Khalid and social, but no, Shita Ajinash Nishnahano, Adet Nesha. The Aja Bandad Nishita Hanon the Shni, Hajo da Batochi, Hajo which Yada Chi, Ado Anna and letting to Yada Chi in the Shni. Beni nan nige nan nishite. Yida house ashi ati oda shno baby hanas ho ko but has ashinan handed na shade hola kocho da ze ko shna ash na lahade ho Karen. Yeah, by the way, up in Cedar Ridge and to the city, Honolulu, capital, Shanto, Ebony na halit ala what and I see the right of way agent right here. And a bed or I think so banana ko what nash ego at you change ako ben nash ego young lady Benant on Nishikaya Benant on Nishi. We have to make sure that they are all on the same page, whether it's Eastern Navajo, whether it's on tribal trust land, whether it's on fee land. So and then like I said, the other issue is that I'm gonna be following that one home that has a service line drop, and they're making that, it looks like they're gonna make that person jump through hoops. And like I said, It shouldn't be because someone approved a power pole to be put there, a service truck. And for NTUA to tell you, you need a home site lease. No. NTUA came in your region and got land consent from the permittee. Who authorized NTUA to put a service truck there? And so you shouldn't be jumping through hoops with the shit. So they say, okay, but I'm gonna see how NTUA handles this. Because just that one constituent there, this thing in Honorable Naz's area up in Upper Fruitland, what if they're in the same scenario, or up in Kayenta or up in Aneth area? There's many other constituents that are in the same scenario, and they're giving different information. I guarantee you, if I called into Shiprock or Fort Defiance, they'd give me a different path. That consistency, I don't got all the things that give I up shoulder and good to go. Thank you.
Yeah, Speaker So for that introduction. NTUA, would you want to go ahead and give a response and closing? Thank you.
Thank you. In closing, if someone's breathing and they're willing to pay their bill, I'll serve them. But I can't run that line until I get permission to do it. And all those hoops don't come out of our policy. It comes out rules and regulations and law that the nation has established. We have to comply with those rules, regulations, and law. If I submit it and it doesn't have the required documents, it gets rejected. It's not, I'm not the one that's doing that. I'm only communicating what's required by the nation. I applaud this committee for looking at that and trying to pursue change in those rules, laws, and regulations to open up the doors to get rid of some of those hoops. That's what I heard this committee trying to do today. And I applaud them for that. Willing to partner with them to that. Yeah. But Delegate Simpson, my heart goes out to you because the BLM and state stuff, it never really gets dialogued in the degree that we talked about everything else. I think it's important to get a representative from BLM and the state into the room and let's negotiate through them all of these types of things. And if you will allow me, we will try to find a contact and we can arrange the meeting. If you're there and any other pertinent individuals that need to be there, we can try to start the dialogue. Because it's something that's long overdue. But again, we're willing to serve anybody we can. We just need the doors open. Thank you. Thank you everyone for allowing us time.
Thank you, Wei, for your presentation. Real quick, just want to let everybody know that we got refreshments, water, coffee, pastries, go help yourself while you can eat over there. Okay, we're gonna go ahead and move on to item H. We're gonna move on to item H. Okay. Honorable Simpson.
Thank you, Mr. Vice Chair, members of REC. Good afternoon, Nike District. Mr. Vice Chair, since we're talking about consent, and right now, thank you, Mr. Coots, for your presentation. And I know you talk about some issues you're facing as getting consent for water line project, power line projects, all that. So I believe I need to ask a question to Indian Health Services. They're represented by Indian Health Services. I need to ask her a question.
Mr. Simpson.
Okay, thank you, Mr. Vice Chair.
Mr. Simpson will, Delegate Simpson, we gotta be out of here by 3 p.m. Everything's gotta be wrapped up, so, IHS is not on the agenda, but I'm gonna go ahead and allow you to ask that question. Let's keep that.
The reason why I'm bringing IHS up is they serve a lot of the water line to our Navajo people on Eastern and Big Navajo. So question will be going to Indian Health Services. If Indian Health Services is opposing a water line to a community and has to get consent from grazing communities. For instance, if one grazing permit is asking for compensation and IHS is saying, no, we can't compensate. And so the grazing permit does not give consent and tries numerous times, try to get that consent, but the community continues to ask for compensation, but it doesn't happen. So the consent doesn't happen. So what does IHS do from there?
Hello, my name is Stevie Hudson. I'm with Navajo Area IHS. I'm the realty specialist. So to answer your question, when a permittee doesn't consent, it just kills the project from there. We just stop all the paperwork, everything that we're doing to gather all the pertinent documents for that project. We put everything to a halt, and then the money gets sent back to Washington.
Okay, that clarifies. Okay, thank you. The reason why I bring this up, Ms. Vice Chair, members of the RDC, is that we definitely have to address this grazing permit consent, because we do not want IHS funding to revert back to another different projects, or go back to Washington DC. Same with ARPA. I believe that we really need to address this grazing permit consent to get these projects going. And like I stated before, we do not want money to go back to DC or revert to other projects or lose ARPA funds. So so that clarifies why it's just, if a grazing permit does not consent, that money, they just stop the project and just goes back to DC. Thank you, Vice Chair, members of RDC.
Okay, thank you, Delegate Simpson. I got a quick comment by BIA Superintendent, Mr. Solsi. Thank you. I know time is of the essence here, but I'm really surprised to hear that from IHS, that a permittee was just shut down the project, which is alarming to me, us Eastern. So what I would recommend is come to us, work with us, and figure out how we can work through that part of the challenge that you guys are working on. And we can't be, I don't know, unilateral decisions and saying that this one permittee can shut down the project. So please come to us and we'll help you where we can. If it's on allotment land, that's our direct responsibility. And we worked on a lot of IHS projects. And of all the projects that went through, gosh, 99% of them, I think, went through the process, and we approved it. On Tribal Plus, I think we have a similar record. Those applications that came to us, we've approved them. Thank you. Thank you, Mr. Solsi. Go ahead and take it to Honorable Solsi. Let's keep it short and sweet. Okay, thank you, Nana. On the IHS, I would encourage just clarifying everything, saying pass a law that says no consent, no grazing consent shall be required for water line and power line, so long as the land is reseeded. Period. That's it. Then we're done. Because if you go out there and you see some of these water projects, we overgraze on both sides. And then where they reseeded the water line, that's the green part. It doesn't make sense to me. And so long as the land is reseeded, then the land is of more value. And the other one too is I think they were doing the Gallup San Juan lateral project. And there was a person there saying this is my land. So they did a real estate survey appraisal out there. And they told them that, well, the value of the land was about $1,000, but since you overgrazed it, the value of it is now $300. And that's what's going on out there. And so then the person just spun around and took off.
because he wanted $2,000. These things don't make sense. But the other one, so on the IHS, yeah, I think we can do that. And then IHS, when you pass the law, will honor that. And then no permit, you know, because it's really holding up projects. But the other thing too is we had a good session with Eastern Navajo Land Commission and the RMPA in New Mexico. And what they're asking for is this is surface and subsurface. So I think maybe this is where maybe we should do a comment on the use of BLM lands and the consent part. And I think the RDC in consultation with Eastern Land Commission could provide a comment to that process so that BLM will incorporate it into their RMPA in the next go round. And then so for Navajo homes that are being done, this is the new process. And I think that could be done. On the home site lease, if you go to the turnoff to Coyote Canyon, there's a need to do home site lease. You know, it provides for management too. But if you just say no to home site lease, it becomes chaotic out there. I attended a District 16 meeting at Red Rock, and all the chapter officials were saying that based on what President Nygren said at Fire Rock, that, you know, let's push the home site lease to the side. And then all of the people stood up at the chapter house saying that we don't need home site leases now because the president said so. And I want a water line now. I want a power line now. And then it put a lot of burden on the chapters, you know, because the president made that comment. And so, and I think that there is a need for home site lease, but the question is, how do we make it easier for them to do so? And I think we could, I know there are certain archaeological surveys that have been done. All of that, maybe we could somehow put it into computer because now we work with digital. And so that if somebody's already has done a home site or archaeological clearance, there's no need to redo it. Then you know, an approval can be done. But the other thing, I think, Mr. Chair and members of the committee, is there are 406,000 Navajos out there now. 204,000 want to come home because over half of the Navajo people are off the res now. And they want to come home and they want to live among us. And how do we do that? Because if you require permittee and consent and everything, those people are getting frustrated. I think all of our division directors are living off the reservation now because they can't get a home. And it's crazy. And how do we allow people, good people that want to help us to live here among us? And I think we need to start encouraging a home site areas along these roads to where it's pre-approved and everything. And that way, when somebody asks for a home, they say, oh, there's no permittee saying no. You know, then you have people, you know, the RDC directs the person over there. And we could just do this across the Navajo Nation along these roads. Because at the moment, and I'll give you an example, over at Coyote Canyon, the turnoff there, somebody illegally set up a burial ground there. And this is prime land at the intersection. And so that prime land out, because of that burial grounds, there are 2 or 3 burial grounds there now. And, you know, I encourage you to look at it. The family plot, I know. And so because of that, the value of that land has gone to 0 because you can't develop it. You can't do any economic development there now because of the burial grounds. And this is what's going on out there. And it becomes so chaotic. Because with Eastern Land Commission, we're trying to deal with these land management and try to encourage good sound management. And then, you know, to have people living out there and also for businesses. And if businesses can't move out there, then there's not much we can do. There's no revenue to the tribe. So, little bit decision and I could I show them come on some case so I hide the yeah. Okay, Honorable Sosi. Okay, we're going to go ahead and move on to item H of the agenda. The presentation on issues relating to obtaining land user consent for Navajo chapter projects, Division of Community Development. Mr. Dwayne Wasetta. Come on down.
Then you called me, I was ready to go sleep back there. Hi, everybody. My name is Dwayne Wasita. Been with Community Develop 6 weeks and growing to 7 weeks. But what I'm gonna cover is what we're working with now is the ARPA. Some of the areas that we're having to work on, and it's great dialogue for chair the committee. This is well overdue. I know there was one several years ago, but I think one of the biggest things is that we all have that common goal amongst entities. How do we get infrastructure? How do we get service on the reservation to our people? And it's true. One person can shut down everything. One person can actually drive other people off. My background, I was with Housing Authority for a little over 21 years. And a lot of what we tried to do was master planning to look at big areas. Well, I'm with the nation now, looking at community development, looking at the power lines, looking at everything that we have. And it's a common goal. And I think one of the things that I'm working with, I need to talk with Ms. Sosi, working with power lines on the Mexico side. Hamas, Continental, trying to figure out how can we streamline this, make it faster for all of us. One of the things that their interpretation from chapter, oh, well, we have a single phase line. Now, if we're gonna put somebody to it, we got to go to right away. I said, no, let's find out where everything's at, put the documentation together. The other things that we talked about yesterday, land consent. I know that's one of the hardest topics. That was, I think 10 years ago, they talked about grazing. And that was one of the topics that I actually had a chance to sit in on. And it's true. I worked on a project in cornfields. When the regional, it was a regional BIA staff was there, he said everybody in that chapter didn't have an active grazing permit. Everything was not in existence to where people could protest, but still, they still had challenges on trying to develop some power lines out there, road improvements. So I think one of the things is that we do need to get grouped up amongst ourselves, where it might go, Rex, all of us. Because the only way we're gonna improve this thing, we gotta reform our policies to make it easier for what we do. But at the same time, meeting the federal requirements as a federal land trust, federal funding sources and other areas, and that can be kind of standardized. I came to community development. One of the things that I asked for, what is our standard policy on how do we put a power line, water line in? Well, they said, oh, look at this thing. They gave me a booklet from 1990. I said, well, a lot of this stuff, a lot of the regulations that are in this policy are outdated or they've been amended. So it's looking at some of those policies of how do we can improve those areas is one of the biggest things. Sometimes I saw my staff a couple of days ago, is it a yellow paper day today or is it a blue paper day today? Because it seems like every time I talk to a certain office, there's a different interpretation and Otto's right, Honorable Otto, because everybody has that different interpretation what needs to happen. But I just want to make it short. And if we want to keep the dialogue, I'm kind of interested to keep this thing moving because there's one of the biggest things is on each agency, it's a whole different game versus now Arizona side. And the New Mexico side is so complex because of the different land status and different requirements. And I think that will probably be one of the biggest items that we need to tackle. Because those are the areas there that probably doesn't have a lot of the services because of the different requirements. But wanted to leave us that. I want to get more and over pressed for time. So you guys left me for last. Thank you.
Thank you, Mr. Wasita. So do we have any questions regarding this presentation? If not, we're going to move on to item I. presentations on ARPA FRF infrastructure projects that currently require land user consent. The presenter is Max Bighorse. Are you here? Got a mic right there.
Good afternoon. General Satana Hashijoji. I'm Max Bighorse. I'm with the, I don't have a presentation. I had one, but it's made, this presentation mainly on consent. So we're with the Fiscal Recovery Office. Our director is Tom Platero, and I'm Max Bighorse. Kian and Schlido, between Bashichindo, Kapan Dashichedo, Sedishkine Dashanala, I'm the principal civil engineer for the Fiscal Recovery Office, and I handle the technical part of the program, technical matters, and we're way at the end. We're way at the end when you get all your consents, when you get all your right of way and all that, and then when you go to construction, that's where we get involved. So we're the funding agency. So just wanted to make sure. Just like Rex said, we just follow the rules. We just follow the laws and the regulations. When Navajo Nation accepted the funds from the federal government, we said from the Navajo Nation that we will follow all the regulations, we'll follow all the laws, and the Navajo Nation laws too, such as home site leases, consents, biological, archaeological surveys for these public works projects. So that's what we're following pretty much. My area is mainly in the technical part of it. A lot of the chapters are going to be building warehouses. And some warehouses are huge. They're twice the size of this room. And we're concerned about public safety. We don't want to make sure that nobody gets hurt when they're building these buildings. And these buildings have a lot of steel in them. And some of them over $1 million per warehouse for a lot of these chapters. So we don't want to make sure that everybody follows the codes. We have the Navajo Nation building codes that was passed over the summer. And Navajo Nation building codes, I believe it's been signed by the president. I don't know if they were signed by the president, yes. So they'll be developing standards. There's already standards established. You have the international building codes for the fire protection systems. If you look up here, you can see the sprinkler systems on these buildings. Want to make sure that everybody follows those standards. We have fire hydrants that are required for public buildings, and such as elevators and things like that. And make sure that they do soil investigations for the larger structures. And then you get sanitation permits that you need for public buildings too. And then also permits, Navajo Nation permits. Want to make sure that everybody gets their Navajo Nation permits for tapping permits for water, wastewater. A lot of septic tanks, drain fields are being planned through the $150 million bathroom additions. So all those septic tank drain field needs permits too from the Navajo EPA. You submit your plans, your drawings, your engineering reports to the Navajo EPA, and they give you a permit from there. So, and then also through wastewater too. If you're putting in wastewater treatment plants, there are permits that are required too. And then public water treatment plants too. They need permits that are required through the Navajo Nation EPA. And there are also permit fees that you have to pay too. So that's pretty much my area of work with the fiscal recovery program. And I think this is a good meeting. I think a lot of the key decision makers are here, and whatever changes that are made here, whatever processes that are made quicker here, we would sure appreciate that too, because we're under the gun
to get all these projects completed. We're a funding agency. The first deadline that you need to be aware about is the September the 30th, 2024. We want to see all these projects under contract. If you're going to build a roof or the building, you need to have all your purchase orders in place. You need to have all your contracts in place with your contractor. We like to see we need to see the buildings under contract if you're going to hire a contractor. So that's the biggest deadline that's coming up is September the 30th, 2024. And if you don't have that, they pull the money back and they put it in the bigger pot, back to the fiscal recovery pot. And you basically lose that money. The next big deadline is December 30th, 2026. And this is when everything shuts down. The whole ARPA program is done by then. So it's a relatively short funding cycle. And mainly it's to prevent COVID. All this started from COVID, prevention of COVID. And a lot of businesses went down because of COVID. And a lot of schools had to be shut down. And majority of our projects are in the water, wastewater. We have 200 and I believe over $200 million in water, drinking water and wastewater projects that we're funding. And we have $150 million in bathroom additions too across the Navajo Nation. And all the delegates chapter projects are about $211 million too. So that's about $8 million per delegate too, just to give you an overall picture. So my recommendation is for this group is in closing is to whatever processes that can be made quicker, easier, more user-friendly. And I think we sure appreciate that from our office because the deadlines are very tight, you know. The deadlines are very short. If you really start looking at it, and what I'm afraid of is a backlog, you know, backlog in getting home site leases, you know, every, you know, how you going to process 1,000 home site leases that come in, you know, and that you would have some kind of backlog, you know, and we can't get everybody approved, you know, we can't get everybody funding, and they lose out on the funding too. So I think that's my recommendation. And that's pretty much all I had. If there's no other questions.
Yeah, Mr. Bakhorst, do we have any questions on WAPA?
Yes, thank you and good afternoon to everyone. One of the things that we at RDC would like to request to the FRF office is if you can provide a listing of your projects and some that have those obstacles in place. So when Madam Chair was here, we were discussing these obstacles that are being addressed today and how many of our projects for ARPA are being affected. So if we can get a listing from the FRF office, and then also how we as RDC can be a part of finding a solution for that. So that was the only request from myself and Madam Chair is if you can get us a list, you can send that via email. That's it. Thank you.
Thank you, Honorable Claw. It was pretty much a more the response comment. Is there anybody else here? RDC colleagues?
Yate. She shaggy yahe Anthony begin she the cheating stock yani basis chin as the say the chin to head lady the shunan. Ado kudabayat yagi you thought it but I'll say it in now in English. I think it'd be for everybody, it'd be best for everybody. But I'm Eastern Agency Land Board, District 16, representing Mariana Lake and especially chapters. I think there's a misunderstanding where a grazing permittee can stop a project at Nindigi. To my knowledge, you can't, they can't. Bahasa Ana. The reason why is it states under Title III, Navajo Nation Code. Out of the duties and responsibilities of the district grazing official, land board, there's Navajo Nation Supreme Court rulings where we can override it. I think that's forgotten about. I mean, it sounds like I'm a broken record. I've said this a lot of times at different meetings. And for us HVAC land boards, I think we're unique, even though we're in a quagmire of land statuses. But it's nice because that way you can learn from it. And I see it as a beneficial position. We've done by action, by resolution, where we've given consent to Cellular One for towers, even though the permittee says no. We provided consent to Indian Health Service for a water line, even though the permittee says no. We've given consent to home site leases because permittee said no. We do it by what tribal law allows us to do. So, and district grazing officials have the same steps, except they have to do a committee and they can only recommend. And they recommend it to Office of Hearing Appeals. For land boards, we make a decision right then and there individually. However, sometimes it's best to bring it before the land boards where they can make it as a whole. Just because land board represented a community. And usually that community is what? Their family. So in order to not have that land board, respective land board, have arguments with their family, we just give it to somebody else. We assign it to somebody else. So to say that is kind of incorrect. Actually, it's wrong. The other thing that Mr. Sosi brought up is a little issue that RDC really needs to look at is District 15. That's where that one permittee is actually saying no, but District 15 by Navajo Nation Code says it's under Eastern AC Land Board. But District 15 by Navajo Nation Code, as it dictates through the land withdrawals of 1880, is left out. And they operate on 25 CFR 167. So those are some things that Resource Development Committee really needs to look at. We'll provide a resolution. We're meeting this Friday to do that. So we have 3 land boards in Eastern that are actually grazing officials. The reason why I bring that up is this permittee who's saying no, actually, it's going to be difficult because Eastern AEC land boards operate off reservation grazing points, which have a different mediation process. But yet that's under 166 because under CFR 160, 25 CFR 166, 166.102, it allows tribal policies to dictate. That's where we come. Tribal policies will actually be accepted by the government. So, but coming back to District 15, since they're not actually Eastern AC Land Board, they're actually under the 25 CFR 167. So that's where the conflict actually comes into play. Do they take the grazing official route or do they take the land board? Well, just out of common sense, it's going to be the district grazing. So, you know, those are the things that we got to clear up. So actually, it's a simple process. If you would approach the land board and say, here, I've got a problem, present it to me. We ask for everything in writing. We ask for all disputes, any complaints, anything that you have a project that's not going, present it to the individual land board and we'll make a decision right then and there. And again, like Mr. Sosi had said, it's for the benefit of the good of the people there. So, you know, it's just, and again, I've repeated this like a lot of times over different places, and hopefully this is where it stops. But I want to do everything in writing, submit it to the members of the RDC, and then also maybe to legal counsel and have them look at it. But yeah, I just wanted to let that
actually think about, have you guys think of that before I leave. Thanks. Thank you, Mr. McGarry, for that. Definitely, I'm looking forward to your documentations and submitting all those. Speaker Soul?
Just pertaining to those two dates that Max talked about, those deadlines, just make sure that the first one you do indicate that as long as the funds are encumbered, they're okay. Don't say these are two deadlines. If it's not done, what I heard is that if it's not being used, you're taking it. The term is encumbered. The September 30th, 2024 deadline. As long as the projects are accepted by ARPA, went through the same the process and has their funds encumbered. Basically, but the hardcore deadline is in 2026 or something like that. So that's just how I comprehended as the presentation was made. But if it's out there, there's a deadline. There's a deadline on September 30th. No, you're gonna say that the sky is gonna fall September 30th, 2023 or 24. But it's an encumbered date. So thank you.
Yes, Speaker Soul. Going on, we're gonna go ahead and give you the floor. Thank you. State your name. All right. Quick question. My name is Lorenzo Early. Sanders, Arizona, Dennisha. DOJ Banasish. Nagani Senator Anabashin. Kiani Dasiche. Tachini Dasna. I wanna mention something back that happened 2018 at baseball and you atadesni sassen fanolya that is so in khayda khachimida it sassen some baseball and ado nikum tkhojisho it's what atadesni ako ade ado how the hadna or naspanadest aya could explore Nina or Nasna Desta. What about this case? I could not that's in so. Those are the could not call around September 2024 where Ado and that obligate that go. It's not a no joke. And I could also that over this case. I hear this all the time because I attend these meetings and how we hold in that's what I want to know. In spite of all the obstacles that we talked about today, and a lot of them, we had to work through them. I used to tell my chapter officials when I was a delegate, you work your projects. You never know when you're going to have an opportunity to have money. Could they know that? You're not over to the or I'd have been that. You got to work these projects. We started out office. So right now, I'm kind of wondering, sitting here thinking, where are we at in terms of how the project's unfolding? Are we spending money? Are we obligating these funds? Because 1 year is not that long. It's going to come around. So what are we going to do? Well, I we can then talk to our chapter officials, to get to see what these projects. Yeah, thank you, Mr. Curley. That question is can it be answered by the FRF, the gentleman that was Mr. Max Bigcore has come back. You had a question on the update on the ARPA, where it's at now, and you can, what you know, just go to share that with them.
Right now, all the projects are being funded. A lot of the projects that need to be funded by the chapters, we're about 90% funded. They're going through what's called a subrecipient agreements. If you're a certified chapter, we deal directly with you as a subrecipient, as an entity. And then if you're not a certified chapter, that goes through the community development. If you're an entity like NTUA, we have subrecipient agreements with them, which is basically a contract with NTUA. For the bathroom additions, we will have a subrecipient agreement with NECA to do all the bathroom additions. So it's basically like another contract too. So, and that's where it's at right now. 90% of the chapters have did all their paperwork, and we're in the process of doing the subrecipient agreements with them. So that's how far along we are. So there's really no more money left. I mean, every dollar, every penny has been spoken for. Every dollar has been budgeted for all the ARPA projects. So everything has been tied down. There's really no more extra money we have. It's just what was in the legislations, the funds that we have, and that's all we have. Now, there might be some extra funds when that magic deadline, September that he mentioned, 30th, 2024. If some projects are not encumbered is the word there, we'll have some more money. And that's up to council, see how they will handle that. So I think that's where the funding comes in, and we have a contingency fund, and there's $500 in there right now. So, and that money goes automatically into the air, you know, whatever money's that left over. So that's to answer your question. So about 90% of the chapters and entities have done all their paperwork.
Thank you, Mr. Request, for that. We're gonna go ahead and move on to a question on this index card. I don't think that was, you already did this one. Oh, okay. Okay. As gentleman has a question pertaining to the presentation.
Yeah, none the committees or attorneys. Question to Mr. Leonard Sosi. He mentioned that there's a kind of like a illegal burial. It's not illegal burial. It's existing burial. 1940 at the wage industry. That's how the family had their extended burial site now plot. That's the only thing I need to question you on that. And then also on the Mr. Anthony Bigay's question, we as a grazing official never said or say no to any construction. When there's a construction going on or coming in or anything like that, we never say no. Also on NQA, the extension agent, they have their own extension agent. We, grazing official, were never been notified until the last minute when that project jumps in there. They'll be running around, letting us know, and we didn't know about it until the last minute. So they need to work with us, grazing official, and let us know at least a month, 2 months ahead of time. That way we'll be aware of and to keep that dispute eliminated.
Thank you for your comments there. We're gonna go ahead and move on to item J, presentation of the legislative process for legislation to change Navajo Nation law. The presenter is Mariana Khan. I'm sorry, Mariana Khan, okay. Where do you have the floor?
Oh, okay, as I've said, I am the attorney for, working for the Navajo Nation Council. Our office, the Office of Legislative Counsel, drafts the legislation that is requested by the standing committees, by individual delegates. After the discussion here, several topics have come up for potential legislative drafting. And the delegates, RDC, who has been Resources and Development Committee members who have been listening to the presentations, are coming up with possible solutions for various issues that have been presented today. And they will, perhaps they need to talk more among themselves about what exactly they think should be a particular legislation request, and or otherwise they might come directly to the Office of Legislative Counsel and put in a request for drafting. The issues that that come up with our office is who is the final authority to make a decision legislatively about a particular issue. Now, if one of the potential solutions was suggested by Mr. Mike Colonna with regard to existing homes and the existing home not needing to go through the particular consent and the particular process for a home site lease. And so if that is going to be a request, that would need to have a particular amendment to the home site lease regulations. That particular approval is solely in the hands of the Resources and Development Committee. They are the final authority. And so that's just an example of where the Resources and Development Committee is final authority. With regard to another higher level, or where the final approval authority is at the council, could possibly be the use of the Land Acquisition Trust Fund to be used to pay for any land user compensations that would come out of the eminent domain statute. And that would be through, I see it going as to the Navajo Nation Council, if that is the request put into the Office of Legislative Counsel. Other issues have been presented but have not been solidified. Again, if it's a waiver for a particular time period for regulations, then that would be a final authority would be the Resources and Development Committee for particular provisions of regulations for home site leases, home rights of way, TAAs, that sort of thing. If there's a particular request for the duration of the time up to, let's say, the September 2024 deadline for encumbering of funds, that sort of thing. If there's a waiver, that would be RDC. And without any particular request, I cannot tell you the particular steps in precisely, but in general, if it concerns regulations, it would be an RDC resolution. If it concerns use of the Land Acquisition Trust Fund, I see that going all the way to the Navajo Nation Council. So if you see a particular amendment that would be helpful with regard to regulations, and I'm addressing this to the Division of Natural Resources and the various departments there, if you see a particular helpful amendment that would be helpful in meeting the requirements or waiving the requirements that are currently been approved, I suggest that you provide that language and give it to a member of the Resources and Development Committee. Mr. Vice Chair, that's all I have to offer at this moment.
Thank you, Mariana Khan, and well, thank you for all you do. want to, a card here by Mr. Zani. Stating that, all information is good, CARES failed to give funds to chapters and communities. And the recovery programs sound good, but DCD failed last time, and that's not what, we don't want that to happen again. We want to make sure that all these funds are expended and, for the best interest and the service to the net people. So I want to thank you for that, sharing that with us.
That is Nana, to add to that, why I'm saying this, the question that I submitted is, I was the chapter official for a couple terms. So when the COVID first hit, she did the kind of chapters within the Hasna, no, earmark it, yeah. At the end, nobody came forward to help the chapters with the whole process. So what happened? All that money got returned back to Winter and at the end of the never cost name. So because of that, what Mr. Maxim said, community development, Mr. Patero, and then community development. I don't know how the relation is. And who exactly is in there designated to assist on these projects? As far as I know, I'm just a regular common person out there in the community. But in essence, at the chapter level, even the officials, what makes it even worse for the community of coal mine is that we don't even have administrative staff. We have not had that for about 2 or 3 years. So odd then. And then with all this meeting that is happening today, how many chapter officials are here? How many just people, common people are here? So the communication gap, from here to there, there's nothing. The only thing that I get is people that I know. I talked to Otto and I got to know Mr. Nez and people like that. Other than that, the real information that is to be in that process, to work in that realm, developing projects. Again, so as people out there, we are lost. The questions are there. And there's no answers. So CARES Act failed the people, failed the communities, failed the chapters. So how long have we had this money? 3, 4 years, so that's what I'm saying. It's just the process that is red tape, red tape and bureaucracy. It's so much to deal with. All the stuff that I listened to so far, we're talking about rules, we're talking about regulations. You gotta do this, you gotta do this, you gotta jump this hurdle, this next one. I just say about one year, tomorrow, it's called 90,000. It's the frustration that I'm expressing to you. That's what I feel, having been at a community development at the community level. And then I also did work here in Winter. So I am aware of what all goes on, what's all happened here. So other comments that had been made, those are real. So who's going to listen? Who's going to take the whip out and crack the whip and make people get down there and get busy? So I'm just airing out my frustration, just to share that with you and to hear it. And I appreciate the opportunity of giving. To express our frustration to you. So I guess I'll say on people's behalf and on the chapter's behalf and they need to know what's going on. And yes, those deadlines are good. What good is it? Nobody does anything. So with that, should change. I don't need it. Is my my information source also too. I just kiddos like he's not reading. So people like that, that's the only way that I get information. That's the only way that I know what's going on at this level. Other than that, other source I have is YouTube. Because I listen to you guys. I hear what is being said. But on YouTube, people like us, we can't be participate, we can't be involved to air out and make comments to what's happening at this level. So either they are both on situation, or it's not here, members.
Okay, Mr. Filzani, thank you for your comments and definitely make sure that the community development, is working with the chapters and as well as the FRF office. And I'd like to turn the floor over to Chairman Rick Nez. You have the floor.
A man once said, "That's a little associate as a national. I'm tired of eating fried potatoes. Please take me to town so I can have some French fries." It wasn't him, and I'm just teasing him. So don't take that. Don't pass that around and say Leonard Sosi said that. So. But they were on the 22nd council. Lorenzo Curley, Senator Sosi, Delegate Sosi, I don't Danny Simpson. The reason I mentioned the potatoes is back then, when they were eating fried potatoes, they were faced with these same similar situations, same issues. 24th council that you have French fries. That's it. Corona moving forward, maybe they'll have sweet potatoes that they can fry and make French fries out of it. So, yeah. So, thank you all. From GLAD, Minerals, Land Department, Department of Ag, NTOA, FRF office, BIA, and Department of Justice. The Kurok and I kiss Kanti by Yale Halate our aid need. Here got it Ms. Condom, Ms. Quinn for on his Department of Justice. I don't think it is a trustee, but the Nenagada BIA. Or could the Nithiga $1.8 billion, okay? At 80 peso, okay, we don't want this, not even a penny sent back to Washington, D.C. September 30, 2024. Some of these monies are going to go back to the controller's office the way the legislation is written. Encumbered Elia Goko. Eben yes, Edenils and the need none. Oh, Beso to I Sebachada, Yakishi, that's order never change that he atan. A colana ain't and the net hope doors and Ishbara had all Tito did a job, but he don't sick case basically cheap the Nenegi Bayat and Onegi. Out of Badahido after Beso Conenda the net Kodok at the Bebenal source that they source. Wait, oh, dear, Behados, the Koron has twee and Nagada or check but the neither on Hani again, nature had Zico, Neda,
local level that the dito grazing official or land board what I better husband that sa or job better husband sa need to go by is the spend the cat quid asana fedo as name at ziko shiba nada e need to less the not to the job at chohdot as a share that is data. I've got a text that says, how do I submit my recommendations? Recommendations, advisement, need. I don't add in a 5-day comment period, the resolution, legislation for the Liago, Neneki, the Nebuchadnezzar, Ade, nature. Yet, Osnech, here what they needs, and the whole Avanti case that I don't need, Hikishi, and Santida, a Colago, eminent domain, about the compensation. Art and the Nebuchadnezzar house and though did a call rights of way, or chonko del echo a desk or topahaki as land asahate as la. Aro kera el fanana chiato national era hazanigi benefit in the hazana and la. Aro TAA bidi nenege Tribal American Airlines. Tribal Access Authorization. So should not I Hagina had no Shivan Sahak case data. About a streamlined ordinance. Dila Jopa Kokodo Nasiki Cheta Gahi Kodopes Ogo Yigat the radio J which Asande Zadoba Arats and the Adadoka. Then again, that's your hold this got the walkie quarter horse again, corruptal, also the quid had ginger DOJ, so stop or little cochonana, but had on a streamline again, laughed and never house and all they put out. Been in the stove and a height, Arabici 8. What a get that of chain. Don't I go? I don't that the and that for had a kiss on the better go the stock out touch the yacht. It's in a shnana art and a kalana edlin hidden. Corona had adi hid a deal so into a corot for did Nekabeth. Put on that it all turned they wrote, said, oh, I staggy, it's not set up at a dead, I don't let the BIA, Satoid or better that it elected a TAA, a land department, a large director, and then gave by him data, a coid or sunshine, RDC, which is can't it that you put out any all streamline. Every Wednesday, Night Leko, Lagonal so that and all that, Japan, has it hard or late. Up the land department, director gives you a card, Legoy, lines, Legon, at organ, and all sorts of the Pasco Villa. A lana eat late, you would have hate the arise, dice not target. So the narrow again of Senegi, what ego a hadi. But as I give a kick out on needs and go in a big nation and I know Senegito are Neka and Nashwoki, Kohonsa, whatever has Zito, the Nara should tax it. It's a overhand city, the neck catcher, when his foot let off it out in Latin. Yan Siki, Siki, a not a hard or Zitonal source either, leave you so here, also in Hilton Ado. Not so here or begin hit for not or left not so. Thank you. God bless you.
Thank you, Chairman Nez. We got a Honorable Simpson next in queue.
Thank you, Mr. Vice President, Vice Chair. So members REC, those staff, I didn't say, I'll just make it short here. I'll just say council. I've been working, Mr. Sosi did mention this project and the BBN9 we're working on, that's going to benefit 9 to 11 chapters for water line. And starting from the 491 Gallup water line project. And that's going to be extended to Coyote Canyon, Windish Key, Standing Rock, Crown Point, Vicente, Smith Lake, White Rock, and Lake Valley. And it's very crucial that we need to get this rights way approved. And again, as mentioned by Mr. Sosi, one grazing community is not willing to consent on this rights way. And that's where the hope is at. And we've been trying to work with this for the past 1.5 to 2 years. And one of the recommendations that we're working with Sauter Miller on this project here. And how do we go about trying to get this consent from this one individual? And it's not just happening with this problem, it's happening throughout the Navajo Nation. And how do we go about it? One of the recommendations that came from 27 chapters through resolutions. And we submitted those resolutions with the cover letter to Austin City Council to draft the legislation. And it's working, not just basically saying that if this person, Grazing does not consent, we can just go forward with if it's proposed that way, the language. It's working with the grazing permittees. If there's 10 grazing permits in this project here that we have to get consent, if 50% of those grazing permittees on this project says okay, then the rights will be approved. That's one recommendation in this, these resolutions. So I'd like to request, let's say council, if the office be pursued to draft that legislation, let's put it before Resource Development Committee. And let's see what they say, yay or nay. Because we really have to have these type of situations resolved. And I was talking with one individual a while ago, and the deadlines were mentioned, September 30th, 2024, where these funds need to be obligated. These ARPA funds. Now, for the construction of this BBN9 to start, we have to have the rights to approve. We have to have that to show that we can obligate these funds for construction. Now, if we don't have the rights of way, we can't get this project out. So we have to get this rights of way approved before we can do bidding out this construction. So we have a year to get this project where the rights of way gets approved before September 30, way before September 30, because we still have to do the bidding process. We have to do a lot of things to make sure that this funding will be obligated and is construction ready. So I'd like to request this, let's say council presenter, was the last presenter, I'd like to request also let's council to start drafting that legislation. I'd like to present this to RDC, see what they think. If they say yay, great. If they say no, we'll definitely have to tweak it or amend it. So members of RDC, my colleagues here, I'd like to make that request to have that, let's say, drafted ASAP and to make sure we get that before, let's say, not let's say council, but to Resource Development Committee. Again, I have to respect my colleague. I'd like to present this proposal through legislation and see what they say. So that's my recommendation. Then going back to compensation, we really don't want to open the door for compensation to the grazing committees. The reason why I'm saying this, if we compensate one grazing committee, the other ones that consent will be asking for compensation. It's going to be domino effect. So we do it in one area, and other areas hear about it. Guess what? Every grazing committee will be asking for compensation. So it's going to be a domino effect. So we really have to be careful what we say compensate grazing committee to get your consent. To me, again, the landowners, it's Navajo Nation. So the landowners, I believe that we are the ones that have to decide if we get consent or not. But right now, these waterline parkland we're talking about, we have to make sure that we give these waterline to the people that need these infrastructure to their homes. So I did each get this discussion with the Office of the State Council. I'd like to get those, get that legislation drafted and get presented to Resource Development Committee. Yeah, thank you, Mr. Vice Chair.
Yeah, Honorable Simpson, we'll take it over to Speaker So.
This legislative process on Mahon. Remember, legislative process is triggered and developed by legislatures, legislative branch. As Ani Janasmo. I don't set not that the president is not so easy. Vijika is the best Ani Hatiyai big that adon nishne. That's his marching orders to his programs. And if this legislative process here came into whether it's any policy, was like ARPA legislation, is what Advia. A lot of the program knows what their issues are. Tribal entities, NECA, NTUA knows what the issues. They run into this wall. Even with the tribal program, they say, hey, we have this policy in place. We have this in place. That's why we can't move forward. Since ARPA has been legislated to today, no tribal program, no tribal enterprise has brought in legislation to change the law. So RDC, EQUAD, let's change this process, or let's do a waiver internally of something of tribal authority. And what I'm getting to is that, as an example, a budget season on the budget session. Thursday, we're gonna have binders on our desk. And program directors are gonna be at the front of the table saying, I want this much money. I want this, and this is what my need is. It's for the people. It's for direct services. And that's what I'm getting to. That direct service based on whether it's Department of Education, whether it's Department of Transportation, whether it's DNR, whether it's community development. We haven't heard any coming from any of the enterprises, even from water resources, what they're running into. Taking oath to today, even with Resources and Development Committee, we have no policy change, amendment to, whether it's to a plan of operation or an amendment to the tribal program. What comes before the committee is we need more money. We need more money. We need more money. We know that. But what I'm getting to is that we know that there's not enough money. We know that there's a lot of vacancies there that are out there. You know, how can we close this gap? And really hope that and that triggers back to the communication at the local level. So the never wasn't don't be now sent and that the executive branch has the biggest barrier, I mean, the biggest responsibility to communicate with the local level, lead, to go out. The last administration, I remember I was at, what did she belong with? Just Aniki, hold on, community development building, that building there. Anything beyond Second Mesa, it's too far for us. This is on the last administration.
was like, what? It's too far for us to go beyond the mesas. And I said, hey, that's the reason why I always say, the world turns only in Wonderock, not out there. That communication, I think, as a program, Mariana Khan to talk about the legislative process. How can we move forward to enhance this? Maybe you don't want to work together. I don't know. Oh, no, I don't want to work with the Navajo Nation. I don't want to work with this enterprise. I don't want to work with this. That's it. That's it. And that's it. But, you know, bottom line is, how do we get to the bottom of everything to try to fix policies, amend policies on behalf of Navajo people? Then the other thing too is that we really need to identify what encumbered means. Thinking outside the box, encumbered. If I have money given to me and I had a project proposal and I put it into an escrow account, that's encumbered. Even though you don't have the right of way, even though you don't have this document and that document, putting it into an escrow account and saving it for that project, to me, that's encumbered. Onsen, maybe I'm wrong. Executive branch, especially the FRF office. Encumbered. Asin hizane ko Tony hiyatas me. Be yahanda sta ko kata hanta inta ko hote. Le na to hata ke even na bashi. Khale ego behas ani ki hajo adi ibn ego adi bin nashkhad. Di shohe di toni. Di akhat ya behas ani di nindorye atsisiko. Nide ani Washington de behas ani apit nijin. Atsisopit nidyago kode ye nask. Hot in sin. So no. Ojosh can no. You have that attitude, that thinking of no. There's the door. And then later. We get home over there. They ask us. I'm going to talk about my area. Mr. Sosi and I have really disagreed on a certain project in my area, and we were round and round about it. At the end of the day, not only in 2018 sewer treatment plant. Today, since 2018, that sewer treatment plant, that money is just sitting there. I'm ready to move that money around now, because
What do I do? Maybe in that we'll be able to move quick. I don't know. But whatever the bench. Lady bears so in your own programs, whether it's minerals, whether it's home site lease, land office, and things like that, provide that recommendation to us. So we could introduce it because anything non no even in a Beijing behas ani ego behas ani make us based on that chihit na kiko igisi behas ani khansala executive branch pata inish president is the CEO. When the money hits those accounts, the programs should be able to run with them. Oh, up in lady. Yes, it's asking, it's not again. Lady in a shadow. Yeah, I just need that. Come from an area where two land disputes crossed me. The 1882 executive order, the former benefits. Has not been none home site ba the hado on the right of ways, Kobe the only late 46 years, 47 years waiting for water, a home to be built, the roof to be redone. I want that in the kid it and the outside as a skate as a special need. Many nani a skate. Oh, over time, it skate. Many nani, but no, a complete and sa. I affect you should go. Hey, the la, Kajala had a hold Head Start, water resources issues back home. Home side and all these other issues. Thank you very much. And they got us leadership.
Yeah, Speaker So, thank you for sharing that, your comments. And again, this is a very informative work session. So that pretty much concludes on our agenda, and we will continue to collectively work together with all the divisions and the departments, just to improve the system, improve this process, the consent requirements, the right-of-ways, the TAA. We want to be efficient in this process, and we don't want to complicate this more than it needs to be. So I'd just like to thank all the presenters that were here with us the last 2 days. The Division of Natural Resource, Land Department, General Land Department, and also the Department of Minerals. Thank you for being here. Yeah. Also, Department of Justice, DOJ, Mr. Irvin Chi, thank you for being here as well. Yeah. Oh, make sure you guys take some food to go. Irvin, don't take some food, take some more. I see you got a bag there, so pull it up. I also like to thank FRF office, Mr. Max Bigworth, thank you. And I also like to also give a thank Mr. Superintendent Lester Sosi, Cheryl Curley, and staff EIA. Thank you for being here. And also NTUA, Rex Coots, and Mr. Martin Ashley. I'd also like to thank my RDC colleagues for being here as well. Also the staff advisor and our RDC legal counsel, Mariana Khan, and April. Thank you guys for being here. Everything that you do. Yeah. So again, thank everybody for being here. And let's go ahead and shut this down. Don't want to be overcharged. Let's take some food, coffee, water to go. You know, don't be shy. I know some of us are probably thirsty and we could take some drinks home to our families. So everybody that's online on Zoom, thank you, for being part of this important work session. No, this is where it's gonna start. This is where things are gonna get done. So, go ahead. Thank you. We are adjourning at 3:32 PM on August 29th. Thank you. Also like to thank the Department of Education